Okay, members, welcome. Just to remind you that this meeting is being broadcast online and throughout Parliament buildings, so I just want to welcome those of you who are watching us. So just to remind you that we'd like your mobile phones to be muted and that no photography or recording of the meeting is allowed. So if you're content, I'll proceed with the agenda. So we have got, first of all, we have no apologies, although we do have 3 coming online. So I see Emma and Carol there, and I think we're still waiting for Claire Sugden to join us. So, members, are there any declarations of interest to make?
Chair, just one declaration of interest. I represent the Assembly at the Council of Europe in the Congress of Local and Regional Authorities, and in that capacity in the last year I have met both the Human Rights Commissioners of the Council of Europe. Okay, thank you. Noted, thank you. Okay, in terms of chairperson's business, I just wanted to mention in the news today we see the story around the retrieval of the remains by the Independent Commission for the Location of Victims' Remains in relation to investigating the whereabouts of Joe Linsky. So I'm sure all our thoughts are with his family today as they await the outcome of these tests. Members, there are 3 outstanding cases in relation to Columba McVeigh, Robert Narak and the new case of Seamus Maguire. So I'm just wondering, we know that the Commission was established by the Secretary of State, but I'm just wondering, because we have an interest in legacy issues, whether we should invite this body, this Commission, before us as well to give an update on its work with the remaining bodies. Is that okay? Yes.
Okay. Lovely. Thanks very much. Okay, so members, your draft minutes are in the table pack. There was one minor amendment that the clerk spotted, and that was with the timing of one of the members leaving the room and coming back in. So just to say, that's why you got those table minutes earlier today. But apart from that, are people content that they're a true reflection of the meeting?
Right.
Okay. Any matters arising? No? Okay. We'll go on to our evidence session. So, members, you'll find the clerk's brief at page 17. You'll find the information briefing paper from the CAJ and Amnesty at page 19. And then there's obviously the strategy for the victims and survivors in there as well. Okay, so you're here today. You're both very welcome. Daniel Holder, Director of the Committee for the Administration of Justice, and Gráinne Taggart, who's Deputy Director of Amnesty International UK. And you're here principally around the Legacy Act and the ICRIR. So thank you for your information, and thank you for keeping it concise. I know that you probably felt that there was a lot more you could have put in, but I felt that it was very user-friendly for the purposes of preparing for the meeting, so thank you. Do you want to make any additional opening remarks?
Yes.
Okay, thank you. Go ahead.
Chair, we're going to split the opening remarks.
That's
and
fine.
I'll start.
That's fine, thank you. Go
So
ahead.
Thanks to the committee for the invitation to be here today. Both Amnesty UK and CAJ are working to ensure a human rights compliant approach to dealing with the past. We are engaged extensively in this work on the Legacy Act. That includes evidence to Westminster and Oireachtas committees, along with meeting and engaging with relevant committees and mandate holders in the United Nations and the Council of Europe human rights mechanisms. Amnesty UK has also been an intervener in the domestic proceedings challenging the Troubles Act, Dillon and others, which is a victim-led legal challenge. Both the High Court and the Court of Appeal have issued judgments in this case, which have significant implications for the Act and next steps which should be taken. As we've mentioned in our briefing, the Legacy Act is a significant attack on rights and the rule of law. It is imperative that the UK Government repeals and replaces the Act with a human rights compliant approach to dealing with the legacy of the conflict, which enables victims' rights to truth, justice and reparations to be realised. It's crucial to recognise that the substitution of established truth recovery methods under the Act, such as litigation, inquests, etc., with the ICRIR, represents a significant shift away from the entrenched safeguards of meticulous examination and accountability. Essential to upholding Article 2 and 3 are effective investigations, which hinge on the active involvement of victims, as well as the transparency and oversight that such involvement guarantees. These elements are lacking in the Act. Furthermore, the conventional approach afforded victims an unequivocal right to remedies, enabling them to pursue reparations and witness the administration of justice firsthand. We are not alone in our assessment and concerns with the Troubles Act, and including the ICRIR, the international human rights community has expressed significant concerns. We've heard repeatedly raised by the Council of Europe Commissioner, the former Council of Europe Commissioner, who expressed significant concerns on the ability of the ICRIR to deliver outcomes that would meet human rights standards. The Committee of Ministers also expressed serious concerns that the Legacy Act is incompatible with the ECHR and will not enable restitution for victims. And in May of this year, the UN Human Rights Committee also raised its concerns regarding the Act, specifically raising the weaknesses of the ICRIR. That stands in stark contrast to the inference given to this committee that there has been an endorsement of that body by the Council of Europe. As we say in our briefing, we are concerned with the increasing qualification by the UK Government to the commitment to repeal and replace the Legacy Act. A unilateral decision to retain the ICRIR and qualified statements that have been given of inquests being restored for those who had theirs prematurely halted are not helpful. The courts have found serious ECHR deficiencies with the Act, including the ICRIR, and among the findings from the High Court was a crucial declaration that the immunity from prosecution provisions is incompatible with the ECHR and the Windsor Framework and therefore should be disapplied. I want to highlight again, as we have in our briefing, that Justice Colton, in giving that judgment, there was caveated language that was used, which was that he could not, at that remove, say that the system established under the Act couldn't provide an Article 2.3 compliant investigation. As we've said in our briefing, that informing that view, there was a heavy reliance on draft policies. We do not consider that any policy can circumvent the Act which has established it and therefore render it compliant with Article 2 and 3 of the ECHR. More recently, the Court of Appeal has found core aspects of the ICRIR to be unlawful, specifically in relation to effective next of kin participation and the role of the Secretary of State in relation to disclosure in cases where previously an inquest would have been required to discharge the State's Article 2 obligations. Following the most recent Court of Appeal judgment, a clear course of remedial action exists. We've already seen the High Court disapply the immunity provisions. The Secretary of State should now immediately move to repeal Section 44 of the Legacy Act, which relates to inquests. That repeal would see inquests return and available for all of those entitled to them, not limited to those who had theirs prematurely halted. Together with the court findings all civil claims, which was that the Act's restriction is also a breach of Article 6, and the corresponding declaration of incompatibility, the Secretary of State can also take steps now to reinstate civil claims and to address in the other court proceedings. The re-establishment of these would exist parallel to the necessary joint working with parties on the establishment of legislation to replace the Troubles Act. I'll finish then, just before handing over to Daniel, by saying that we've seen the Secretary of State make reference to consultation on an agreed way forward. We are not clear basically what form that consultation is to take place, if it's considered that individual meetings that are taking place constitutes that consultation, or if there's something more formal. But what is clear though is that swift action is needed to establish a human rights compliant forward that will deliver for all victims and in doing so contribute to post-conflict societal healing. I'll hand over to Daniel.
Thanks very much. So CAJ's Belfast-based human rights NGO, we've been immersed in the legacy stuff along with our academic board members for many, many years, right through the Stormont House Agreement up to the Legacy Act. We were also involved with the establishment by the University of Oslo with the International Expert Panel on Impunity and the conflict as well, that reported earlier this year. So from our perspective, in terms of opening remarks, the agenda behind the Legacy Act was really to shut down proper legacy investigations and replace them with light touch reviews by the ICRIR. Now, ministers at times, Conservative ministers, quite openly articulated that their objective was to shut down investigations. Now, the particular target was to shut down investigations into the military, but that involves closing down everyone's investigations. If you look at some of the policy papers that were declassified by the High Court proceedings, it's pretty clear the previous government rejected options to continue the existing legacy system known as the package of measures and to reject the Stormont House Agreement precisely because it would have led to continued investigations into veterans, and instead wanted a light touch review body that would be subject to a level of ministerial control as well through what's become known as the national security veto, which is a ministerial power essentially to conceal human rights violations by agents of the state over the content of reports issued by the ICRIR. Such power doesn't exist over the existing mechanisms like inquests, ombudsman, Operation Canova, etc. Some similar issues do arise with some of the ministerial powers under the Inquiries Act 2005. When the ICRIR Commissioner for Investigation was before the committee, I think he said that the only option before the commission was set up was a criminal investigation. That's simply not correct. If you look at the package of measures, previously, the previous system, you have mechanisms such as the inquest system in civil cases which don't involve criminal investigations at all, and you've mechanisms like the Ombudsman and Canova that, whilst can have a criminal justice output, most of their focus is on reports. The objective of shutting down the existing legacy investigations was achieved essentially by the Legacy Act on the 1st of May to make way for the ICRIR. Hundreds of PSNI legacy investigations were shut down at that point. 38 inquests were, over 300 ombudsman investigations. It also banned all future civil litigation cases. And it did this at a time when those mechanisms were delivering substantive historical clarification and information recovery for families like never before. And I think it's important to reflect that the previous Conservative government, in context of Labour having given a commitment to repeal the Legacy Act, the Conservatives rushed to set up the ICRIR. They recruited its Chief Commissioner before the bill became law, and against a backdrop of relentlessly withholding resources from other legacy mechanisms, offered this new commission £250 million. It's very much their mechanism for which they've set the legislative framework, for which they've appointed all the people who run it, and which they're clearly very keen to keep, largely because it clearly must be delivering on the agenda that they had. If you compare the legislation, what was in Stormont House to the ACI, you can see key differences. Under the Stormont House Agreement, there were clear duties to codify that investigations must be properly ECHR compatible. All of those have gone with ICIR reviews, as they're called in the legislation. Now, Labour and other opposition members of the House of Lords tried to amend the legislation to bring in requirements that the ACIR would have to follow the ECHR requirements, would have to follow the sort of learnings from Operation Canova, etc. All of these were rejected by government. So we've ended up with a very weak light touch model involving a high level of discretion. Now, it's been quite a difficult battle to get case numbers out of the ACIR. We ultimately pushed through freedom of information, and ultimately, on the back of that in August, they revealed they only had 8 cases, 8 investigations. Essentially, it actually turns out that figure was lower because that included sort of multiple requests for the same investigation. So 4 were Guildford, for example. So it was between 2 and 4 investigations. The current figures that they released more recently mean there are actually 5 investigations, so 5 cases on the back of hundreds and hundreds of being shut down. Now, from the outset, you could say, well, that looks like a failure of an institution, that families don't have the confidence to go to it. However, in another sense, it's quite a significant victory for the agenda behind the Legacy Act, which was essentially to close down legacy investigations that were happening. Sometimes the ACR will quote the figure of the number of inquiries it has had rather than the number of investigations, which is either persons who've approached it decided not to proceed, or what we're also picking up is the risk that people are being funneled into quite light touch reviews rather than proper investigations. Where this is at, and Gronier alluded to this, the ICAR Chief Commissioner before the committee said there was a clear endorsement from the Council of Europe, and that's deeply misleading and is profoundly wrong, and the actual positions of the Council of Europe have been read out already by Gronier in terms of their mechanisms. They've also been echoed by the United Nations. So the United Nations Human Rights Committee met in Geneva earlier in the year and called out a number of things about the Legacy Act, including the weakness of the ICRIR review function, calling on the United Kingdom government to instead, and they quote, adopt proper mechanisms with guarantees of independence, transparency and genuine investigation power that can discharge the state parties' human rights obligations, deliver truth, justice and effective remedies, including reparations to victims of the Northern Ireland conflict. Where things are at is the Irish government, that was the other party to the Stormont House Agreement, has called for substantive root and branch reform of the ICRIR. From our perspective, only a process that produces an institution that's unrecognisable to what's there at present will work. But that's not really rocket science in the sense that the work has been done. There's draft Stormont House legislation that was negotiated over many years sitting there. There's also the opportunity for learning for Operation Canova. So in reality, this is now really a question of political will, of getting this over the line.
Okay, thank you. And I really appreciate you coming. Obviously, we would usually have departmental officials coming, and I appreciate you as our NGOs, so we'll try to extract as much information as we can without too much hassle for you. So, Gráinne, you had mentioned there around the UK Government Secretary of State had indicated that he wanted to propose a consultation on the way forward, but there's no clarity yet. So what would that consultation look like? You know, if you could write the script on it, what would it look like, and what would you think that it proper engagement would look like as well?
I think it goes to one of the points that Daniel has just mentioned on our behalf, which is we're not reinventing the wheel with this. So there has to be a balance struck between the need to consult with all relevant parties, including the victims are obviously central to that process, but also recognising that through Stormont House Agreement we have a roadmap for the way forward, and there is obviously the opportunities to learn from Operation Canova. So the Secretary of State is referring to consultations, but it seems to be at the minute that he's referring to individual meetings that's taken place with the NGOs, obviously including ourselves and others, or if he has envisaged something more formal at a later point, because what we haven't yet seen or heard any developed thinking from the current UK government is what the replacement legislation to the Troubles Act would look like. So we have the commitment to repeal and replace, but very much the conversation focused on replace, and thinking of the current UK government, there isn't clarity on that point as yet. So we're not reinventing the wheel. There should be obviously thorough consultation with all interested parties, but we do have a strong, solid foundation in Stormont House Agreement, particularly with adjustments in respect of Article 3, where we can easily find a human rights compliant way forward on these issues.
Okay, thank you. So in terms of the Irish Government's interstate case challenging the Legacy Act, what is the status of that? And also, if you could tell us the sort of timescales that the Secretary of State has himself for the local judgment, in terms of how long he will have to make a decision as to whether he'll appeal.
Okay, so if I take the court,
Yes.
the current position with
Yes.
the courts just at the moment. So the Court of Appeal, following its judgment, has given its order. It's very clear from the court order that the Secretary of State could repeal Section 44, so that wouldn't therefore limit the reinstatement of inquests to those who had them temporarily halted. It would also leave open new applications for inquests. Obviously with civil claims, they also now can be reinstated also. So the Secretary of State can really get on with the job of doing that now. He could do that through a remedial order under Section 10 of the Human Rights Act. He could do that through primary legislation. I suppose our view is whatever is the quickest, obviously, legislative mechanism to achieve that. As far in terms of a decision on this, the Secretary of State has obviously signalled to the Court of Appeal that he plans to seek leave. He's seeking leave to challenge the decision of the Court of Appeal to the UK Supreme Court. So that's where that sits.
Is there a time scale within which he has to make that decision? No?
So, well, he has signalled to the court that he wants leave.
Okay.
Obviously, formally signalled to the court the application is there that, for it to go to the Supreme Court. It's the time frame sort of beyond that in terms of a decision of the Court of Appeal and the UK Supreme Court. It's a bit hard to predict, but there is a decision pending from the Court of Appeal as to whether or not to give that leave. In the event that they decided not to, then it would be within the powers of the Secretary of State to apply directly to the Supreme Court. So that's the process that we now have to observe.
Okay. The interstate.
In terms of the interstate, I mean, the interstate case was lodged by the Irish Government in January. It's still there, and it includes issues around ICRIR independence. For example, now the court may look. Now there's a new UK government that's promised to repeal and replace the Legacy Act. So initially, it may have been looking to see if there was going to be some sort of friendly settlement in this case. But so far, the UK government haven't moved to do that. It's not clear ultimately what they're going to do, and it's important the Irish government does stand its ground, because that obviously is a significant international mechanism to ensure that what's ultimately produced is compatible with the ECHR, the European Convention on Human Rights.
Okay, one more for me. I'll bring others in. I've got a couple of others if I have time. But so obviously, we as a committee, we have a responsibility to hold the department to account over victims and survivors and support. Is there anything that you think that we should be doing proactively, either within the Executive Office or the British Government, or is there any role that you think we should be advancing?
I think it would be good for this committee, and a very important entity, to press as much as possible the concerns there are about the Legacy Act and ICRIR, because this whole process, and I know that the Executive has responsibility for victim services and things like that, but this whole process particularly for families who had the rug pulled from under them, who'd been waiting for years for a case, for an inquest or for another mechanism that was almost coming up. This has been quite a re-traumatising experience for many, and that's something we need to be quite cognizant of.
Okay, thank you. Bring in the Deputy Chair. Thank you.
And thank you very much for your presentations. Both have been very, very helpful. I think it's quite clear, both from the comment that we've had prior to the creation of the current legislation and also to your presentation today, that the ICRIR is not, and will never be fit for purpose. How do you see the government acting in good faith to its manifesto commitments? Should they repeal before replacing the legislation, or should they simply set the clock back and then go out to that consultation? Because Stormont House has not been completed or brought into the full legislative framework. But what we had before, I think, in your view, and certainly in the view of victims, was infinitely better than where we are today.
Yeah, I mean, I think, we and indeed victims had the expectation that when the UK Labour Party committed to repeal and replace the Troubles Act, that repeal would mean repeal. We've heard the Secretary of State say that he can't repeal the legislation, that it would leave a vacuum. That simply isn't the case. It would mean a de facto return to the package of measures prior to the 1st of May, obviously when they were brought to an end under the terms of the Troubles Act. So the Secretary of State can absolutely repeal the Act in full, whilst then the conversations and negotiations then are underway around what should repeal or what should replace the Troubles Act.
Yeah, and I mean, it was simply not true to say that there was a legislative vacuum, because had Labour moved quickly in July, you'd have only essentially repealing the Act in its entirety quite quickly would have transported us back to the situation that was there at the 30th of April, and the existing system would have continued. As time goes on, obviously that makes it more and more difficult, which is why this delay is such a problem. It's going to take a huge amount of work to transform the ACRIR, to repeal the legislation and transform the ACRIR. The legislation, of course, in theory could be fixed. You could look at every single aspect of it, and it would be a very different piece of legislation that's already sitting there, and completely reform the structure. But I don't think that's actually going to be enough. If you reform an institution on paper, there's going to have to be significant changes to leadership and the people running it to ensure that it builds public confidence. And there will be plenty of experts in this area out there who, when this institution was opened, wouldn't have touched it with a barge pole because of the toxicity of the Legacy Act. So that type of expertise that is out there won't be part of this institution. So it's going to need more than a fix on paper. It's going to need a distinct institution, but at least the model is already there and was teased out quite well.
Yeah, and just to add, I think, borne out in the numbers, that the very tiny numbers that we see engaging, with the ICRIR, it simply doesn't have the confidence of the community it's supposed to serve.
And given its provenance, it is highly unlikely, in your view, that it would ever gain that confidence, no matter what policy changes you made to its remit.
Yeah, I mean, to be clear, policy isn't going to circumvent the Act which has established it. In the event of new legislation, it's still not going to address that the current personnel have signed up to this body with the intent, obviously, of the previous government and bought into that process. It's very difficult then to ask and expect victims to have confidence in that process.
Just very briefly, Chair, one final question. In respect of that very brutal cut-off point where everything stopped, what guarantees do we have that everything that was in preparation and in train up to that point in time for victims remains and is protected when the Secretary of State hopefully does what they promised in their manifesto, and that is reverse this legislation?
Well, the longer the time goes on, the more complicated but not impossible that gets. So if you look at the issue of inquests and civil proceedings, the Secretary of State has made very clear and consistent commitments to reopen civil proceedings. But he can do that now through fast legislation, including the use of remedial orders under the Human Rights Act because of the Court of Appeal ruling. So get on with it. Just do it, because the courts will still be there. They can set up with things like inquests in terms of the infrastructure. Again, the longer it's left, the more an infrastructure would need rebuilt. But we have a declaration of incompatibility that the ban on inquests in the Legacy Act. So again, that can be done quite quickly, including through remedial orders to open it up. So really, these things that have already had quite clear political commitments, quite clear declarations by the court that the legislation is not ECHR compatible could be remedied fairly quickly, which would help build confidence whilst the broader legislation is also repealed and reformed.
So in reality, we have a political party which is now in government saying what they're going to do. We have courts telling them what they want to do is exactly the same thing. So why do you think they're not doing it?
Well, this is what is deeply frustrating for everyone, and deeply frustrating that there's a sort of, it's very unclear. There's a process there. There is some engagement, which was better than the previous government in terms of the Legacy Act didn't consult with the sector at all. But there does seem to be a lack of clarity about why this isn't being moved forward.
I do think following the Court of Appeal, and the court order, there is a question to the Secretary of State of why he now isn't taking the immediate step of reinstating inquests and civil claims, because he clearly now can do that. He did say to the Northern Ireland Affairs Committee, he referred to this being a complex process. The replacement legislation, obviously there are conversations there that need to be had, but actually it's not that complex when you consider the very serious deficiencies that the Court of Appeal has identified and the court order, which leads a very clear path to a remedy for that.
Okay, thank you. Brian, please.
Thank you, Chair. Thank you for your paper and your attendance today. Certainly all parties in the Assembly had serious concerns about the Legacy Act and opposed the Act, which created the ICRIR. Certainly from the DUP point of view, we were particularly strong there should be no amnesty, and welcome that was removed. I noticed what you're saying about a number of cases. I do think, Chair, we should write to Sir Declan Morgan, for an update. When they were here in September, he said 85 people had come forward, 10 formal requests, 8 progress. So I think we should get an update on that. I'm sure others would be going to suggest that as well. But also, at the current junction, what is he doing? What proposals is he bringing forward to make the ICRIR Article 2 compliant? And I note that's not you feel it should be totally replaced, but I still think there's an onus on him to bring forward in terms of the court judgment, and we should be asking what are his proposals that we're waiting to hear. In terms of the overall need for justice, and for truth for victims and survivors, it's important that any process is fair and equitable, and we're always mindful that 90% of killings were carried out by paramilitary groups, by terrorist groups. And in any process, it's important that, as I say, that there is a fair and equitable approach, and not something which almost resorts to a trawl of people who served in the state security forces. What are your views of how ensuring a fair and equitable approach?
Well, this was the discussion of the Stormont House Agreement, and what we landed with in terms of the framework for that was a number of mechanisms that would deal with all outstanding cases, that inquests, which, and I know a lot of inquests have focused on cases whereby there has been that have been state involvement cases, though increasingly non-state actors have also used inquests, if you think of Kingsmill, Birmingham, things like that. But the Historical Investigations Unit, the independent unit that was going to be set up under the Stormont House Agreement, was to deal with all those categories of cases. So that was, whilst you look at the framework of the Police Ombudsman, whilst it did have independence and powers to conduct investigations, it was only focused on one agency. And that in itself was quite complicated, whereas with the Historical Investigations Unit, what you would have is an agency that's capable of dealing with all outstanding cases in proportion to those that haven't had a previous Article 2 compliant investigation. In terms of the ICRIR's numbers, so as you say, the 85 figure relates to inquiries that I think last week they'd said had now gone up to 100. The number of actual requests for reviews at the end of August stood at 10. The figures they released last week were that it stood at 14, which means that in the 2-3 months there's only been 4 additional requests. And the overall number of investigations, which is up on the website, is 5, which is actually less than 1 a month since the time the ICRIR was established.
Okay, and maybe just one other related to that, in terms of processes which were going through the courts, and you mentioned hundreds of cases, in terms of the timescale and the ability of the courts actually to process those, I mean, that would have been another concern. That, I mean, some of these would have taken literally decades, you know, to get through the numbers. Have you any view on that, of how any court system would be able to cope?
Yeah, I think if you take the inquests, for example, it was clear that once there was a structured 5-year plan, it was workable and they could be got through. And the barrier really for a long, long time was the withholding of resources. As the previous government has allocated £250 million to legacy, which it earmarked for the ICRIR, clearly resources should no longer be an issue and should no longer be withheld from the court process, so that it has the resources to get through the cases.
Yeah, agree.
Do you want to add?
No, agree. That's exactly the point, yeah.
Okay, thank you, Grania. Timothy, please.
Thank you very much, Chair, and thanks very much for coming along and providing your paper that we could consider before today. Your submission and indeed your oral evidence is very much focused on the UK state. Do you have any concerns about the ability of the legacy mechanisms to get to the truth behind terrorist murders? We've already heard from Brian that 90% of the murders were carried out by paramilitary organisations, whereas your paper and your oral evidence is very much fixated on the UK state.
Well, if you remember, the rationale that was given for the Legacy Act was precisely seeking to close down investigations against the state, and the Secretaries of State continuously said they wanted to halt those types of investigations, so that's the motivation behind it. In terms of your question, do we also have concerns in non-state actor cases? Yes. I mean, the issue with the ICRIR is that it has not been set up in a way whereby its framework requires it to conduct investigations that are thorough in the sense of Article 2 compliance. And that's across all cases. It has the ability to conduct light touch reviews, whereas if you constructed a body as per Stormont House, whereby there was an attempt within the legislation to build in obligations, that when an investigation met the threshold when a case met the threshold for reinvestigation, that it would have to be done in a manner that complied with all of the human rights obligations, and therefore would be a much more thorough fact-finding process.
Yeah, I think it is exactly that point. I think, you know, the ICRIR doesn't provide anything to victims of armed groups. You know, as Amnesty, we work with victims of both state and non-state actors. So if we return to the framework and the foundations of the Stormont House Agreement, the bodies that were proposed under it offer then answers and the opportunity for truth and accountability to those victims also. But we are absolutely concerned with victims of both state and non-state actors.
It's very easy to go after the state because there's paperwork, there's a history, whereas terrorists didn't keep files, they didn't keep paperwork, and it's easy to pick on one section, and that's a smaller section of the murders throughout the Troubles. Picking up on the term you used there, armed groups, when you refer to armed groups, are you talking about terrorist organisations?
Paramilitary organisations.
So do you use the term terrorist groups?
We use the term armed groups and paramilitary organisations. They're terms that we use.
So when you're dealing with looking at the IRA, the UDA, whoever, it's paramilitary groups or armed groups instead of labelling them what they are, terrorist organisations?
I mean, you can label obviously how you see fit. We refer to armed groups and we refer to paramilitary organisations. That covers all of those organisations who obviously also committed atrocities during the Troubles, during the conflict.
Have you a problem with using the term terrorist organisations?
I mean, from our perspective, we use the term non-state actors as well. I think the difficulty with, and I know we're maybe sidetracking here from the core issues, but the difficulty with that term is we're opposed to all forms of violence. And terrorism tends to be an ideological concept that's used essentially to divide good violence from bad, rather than looking objectively at what each group has done, whether it's a human rights violation, whether it breaches the law. In terms of your assertion around paperwork, I would contest that. I mean, basically in relation to state cases, you can look at proportions and things like that. You obviously have to factor in cases which are state involvement due to collusion rather than the sort of 10% figure which is about direct state killings. You have to factor in the fact that a lot of those cases were precisely those that weren't investigated properly in the first place, in terms of previous investigations. So, for example, if you take military killings in the early part of the conflict, there was over 200 people shot dead by the army. There were no convictions, there were no prosecutions, there weren't even any IUC investigations at all. So there's an investigative deficit there. In terms of paperwork, the experience is that the organisations didn't make a habit of documenting their own wrongdoing. Paperwork and files tends to refer to the investigation files precisely about Republicans, loyalists, non-state actors, etc. In terms of you are of course correct to assert that Republican and loyalist groups didn't keep records and paperwork, but that's why you need a mechanism like the Historical Investigations Unit that was set up that would have been set up under the Stormont Out Agreement that had full police powers, because that's how you investigate those cases. They're not going to be done solely through archives, although a lot of the archival files will be investigation files that are precisely about those incidents. It was very, very rare that the state documented its own wrongdoing.
Sorry, Brian, I think Brian was
Could I come in? Timothy agrees, just if it gives way. Can I ask you, I know we're talking about the whole framework and the context of this, but do you accept under Article 2 of the CHR that killings can be legitimate and lawful carried out by the state, and it allows for that in Article 2, where that is to prevent other killings, so that whilst around 10% were carried out by state forces, many of those were lawful and legitimate.
In terms
and that is provided for in Article 2.
In terms of your first part of your question, is it provided for in Article 2? Yes, any form of legitimate self-defence by anyone to save the life of another person. In terms of the assertion that the state killings largely fall into that category, we can't make a firm call on that until they've been properly investigated, which is why we need those mechanisms. Unless those incidences, you can't take the word of the people who did it, that it was lawful. They have to be independently investigated from those involved. But you're right, of course, there is a...
assume that they all were unlawful?
No, it shouldn't be. It shouldn't be. You're correct. It shouldn't be assumed either way.
Because all terrorist and paramilitary killings were unlawful.
Yes. Yeah, by definition, armed groups operate outside of the law. However, in terms of state killings, until there's actually been an effective investigation, and this was one of the problems of the command paper that underpinned the Legacy Act, it asserted that the vast majority of killings by state actors were lawful. When we asked the Northern Ireland Office for what assessment they'd conducted to reach that conclusion, surprise, surprise, they didn't have one. It had just been put in the document. Okay. So until there's an investigation, you can't make that call.
Thank you, Timothy. Thank you, Chair.
I'm concerned with your language you would use around this. To me, a terrorist is a terrorist. And until we can get to that point, I think we're warm, fuzzy words we're using to try and mask what happened in Northern Ireland. Doesn't matter what side of the divide you came from, whether it be the IRA killings or the UDA killings, a terrorist was a terrorist. Final point I want to ask, have you done any work with the Republic of Ireland government regarding their role during the Troubles? Because they have harboured terrorists and protected terrorists throughout and provided a safe haven that they couldn't be extradited back to the UK. So can you just outline what work you've done?
Sure. In early September, to give you the more recent work, we had a joint roundtable with our sister organisation in Dublin, the Irish Council for Civil Liberties, to examine precisely this issue. And I mean, we've talked a lot today about Article 2 obligations on the UK. Of course, exactly the same obligations apply to the Irish government. We will be releasing a report shortly from that, which has examined the question of the Irish government's responsibilities to ensure that independent, effective investigations, including things relating to the Northern Ireland conflict, but beyond that as well, are also conducted in its jurisdiction. At present, there isn't an independent mechanism that can examine some of those cases, and one of the things I mentioned earlier on the International Panel on State Impunity that the University of Oslo had convened, one of their recommendations was for a sort of Stormont House Agreement Plus model that not only would have established the Stormont House, remember, had a number of institutions. One was the Historical Investigations Unit, independent police type unit that was only to operate in Northern Ireland. The second institution was the Independent Commission for Information Retrieval, which was actually cross-border, which would have examined, which would have been able to take protected statements in relation to incidents on both sides of the border. One of the recommendations of the international panel is that there should be, for want of a better term, an HIU for the south as well as a mechanism within Northern Ireland to ensure that the same type of independent investigations that are being sought here are also conducted within the Irish Government's jurisdiction. And I think there's a fair degree of unanimity around the non-governmental sector on that point.
Yeah, just to say that's also our position, and in terms of our engagement with the Irish Government, I have led a delegation of victims to meet with the Irish Government, including obviously victim of the IRA, and we also got over the I suppose the effects of the Troubles Act obviously on their case and what they want to see in terms of equivalent mechanisms in the South also, so those conversations are ongoing as well.
Any investigations in the South have to recognise that during 73 to 97, 110 extradition requests were lodged by the UK and only 8 of them were successful. There was terrorists used the border to launch their murder and then either quickly disappear back across into the safe haven or actually use the Republic, the land of the Republic, to murder people here in Northern Ireland. And any investigations in the future has to be very clear that the Irish Government have a lot to answer for, how they allowed the terrorist campaign in Northern Ireland to progress and how they facilitated it.
I think it also goes back to a point that we've raised in our briefing paper and also just in our opening remarks around the need for there to be agreement with all parties, obviously, on a way forward. We've seen under the last government that unilateral action taken that departed from the Stormont House Agreement, that departed from an agreement with the Irish Government, obviously, on this. You know, there is a need now for this current UK Government in the negotiations around the replacement legislation to engage, obviously, fully with the Irish Government and for us to collectively reach agreement on those next steps. But as I say, we do have Stormont House Agreement a plus as a very solid foundation for that.
Okay, thank you. Just for bringing Emma, could you give us some figures? Obviously, you've given us some figures there today around the 38 legacy inquest, 335 police ombudsman. How many legacy investigations do you think that if there was a new structure in the Republic of Ireland, you know, how many of those would there be? Are we talking a dozen, 100? What sort of figure are we sort of looking at in terms of the...
You would be talking about smaller numbers if it relates to
Yes.
conflict-related cases relating to the Northern Ireland conflict. Off the top of my head, I think it would be just over sort of 100
Just over 100,
cases.
okay.
Some, quite a significant number of which would relate to single incident in the Dublin and Monaghan bombings.
In Skillen, all.
Okay, thank you. I'm going to bring in Emma. Emma, can you hear us okay?
I can.
Thank
you
you.
hear me?
Go ahead, Emma. Yes, thank you.
Thanks a million. And if I drop out, I've had some technical difficulties today. I thought I had my charger with me to the office. Then at about 20 to 2 realised I didn't have it and I had to scoot home and it's not here either. So I'm having a bit of a day. But Daniel and Grania, thank you very much for your presentation and for the papers that you provided us with. They've been really helpful. I just wanted to pick on a point you've made reference in the briefing note to, I suppose, how defensive Declan Morgan was when he presented to the committee back a few months ago around the references to the Council of Europe and their comments on, you know, the human rights implications of the ICRIR and their judgment on that it was undermining victims and survivors' rights. And during that briefing, I had asked the team around how victims were going to be able to access truth and justice now, and they were very defensive around their process. And in specific reference to the case of Sean Brown, who obviously was murdered in Lahi in my constituency, who the family were trying to get a public inquiry and found out in September there that they're not going to get a public inquiry, and they've launched a High Court challenge to that, and I think they're going to be in court now in the next week or so. But I was told that a public inquiry, the British government were able to block material coming to a public inquiry as well. And the tone of it, I think, was almost, you know, whatever mechanism is used, there's no guarantee that the family are going to get the information that they need. I wonder if you have any comments regarding that.
Yeah, so first in terms of and I mean, I said it earlier on, I thought Declan Morgan's comments about the Council of Europe position were deeply misleading. He appeared to be quoting something polite that a Council of Europe civil servant had said at a meeting with him, rather than the positions of the sort of quasi-judicial and Committee of Ministers bodies of the Council of Europe and the independent sort of experts. The Council of Europe has consistently held quite significant concerns. In terms of the issue about what I termed earlier on the national security veto, the fact is that in the package of measures mechanism, no such national security veto, which is a very codified thing in the legislation whereby anything that either engages the UK's national security interests, a concept that's undefined, or that any information coming from special branch, military intelligence, MI5, etc., has to be pre-marked before it goes to the ICRIR. And then it is not the decision of Declan Morgan or anyone in the ICRIR whether it can remain in the reports. It can be removed by a government minister. So essentially, government ministers have granted themselves a power to censor and redact reports from a supposedly independent institution to in order to remove and conceal evidence about the involvement of agents of the state in human rights violations. Now, it was no surprise to us when the Court of Appeal looked further in this in the context of the ICIR's own proposals that it could emulate inquests, which it clearly can't, that they found that to be unlawful. But I think the important point is, and I thought the ICIR were misleading on this front. It is true that there are similar concerns about the Inquiries Act 2005 that was rushed in just after the original commitment had been made under the Western Park Agreement in 2004 for the public inquiry into the murder of human rights lawyer Pat Finucane, that there are problems with that legislation. A workaround has been found of that because the Inquiries Act legislation does allow ministers to interfere at various junctures of its work, but there is no such national security veto over all of the other comparable institutions within the package of measures. So the Operation Canova reports were not subject to a national security veto in the way the ICIR is. Legacy inquests are not subject to the same kind of ministerial national security veto in the same way the ICIR is. The police ombudsman is not subject to a national security veto in the same way that the ICIR is. Civil courts are not subject to a national security veto in the same way the ICIR is. Imagine if Sir Declan, when he was a judge, had a situation where a government minister was allowed to rewrite his judgments to remove information about state wrongdoing. So I think it was quite misleading in the way that was presented as the national security veto, which, as you may recall, was attempted by the UK government to be inserted into the Stormont House Agreement legislation, which is what caused the collapse of the process at that point. But now it has found a home within the Legacy Act, and it is deeply concerning that the current new government that had promised to repeal the Act seems to be at a point whereby it may well appeal that particular aspect of the Court of Appeal ruling and seek to reinstate some sort of national security veto, which would be deeply concerning.
Yeah, thanks, Daniel. I suppose like everything that you're saying and everything that's been laid out in your briefing note today is consistent with the concerns and the worries that we're getting from affected families here, and I suppose just the disappointment at how the new Labour government have acted after previously promising to repeal the Legacy Act and not being consistent with the wishes of the five main parties in the north. And if you look at in stark contrast to how they've handled the fight for a Bill of Rights, where they have used a lack of political consensus in the north as an excuse not to implement the Bill of Rights, and then in this situation whereby they're denying rights regardless of the political consensus here for the act to be repealed. So it's quite frustrating, but appreciate how clearly you've laid that all out, and thanks very much for your time.
Thank you. Carol, please.
Thank you. So Emma's kind of touched on the stuff in terms of Sir Declan Morgan's appearance at the committee. He was insistent that the ICIR have the same powers of inquiry as a public inquiry does. And I just can't get my head around that after everything that's been said. And then secondly, in terms of the new British government, the Labour government, their commitment to repeal the Legacy Act, they've all, as far as I remember, Hilary Benn, the British Secretary of State, has said that he wants to keep the ICIR. So it's just your thoughts on those 2 points, and I just want to make a small point in the end, please. Thank you.
I mean, I can address the first point quite simply, Carol. I mean, there is nothing in the Troubles Act itself that permits the holding of closed material proceedings or public interest immunity hearings, despite what the ICRIR claims. So you simply cannot draw the parallels between that, obviously, and inquiries. Inquiries can obviously have closed material proceedings. You know, if for a family that has an inquiry, they can instruct a special advocate to look at secret evidence and argue why material should be made public before a judge, and then obviously a judge then takes those decisions. There is no comparison between what a public inquiry provides for and what the ICRIR offers to victims.
Yeah, and just to add, I mean, the comparator really with the ICRIR has to be with the Historical Investigations Unit, and under Stormont House, because they're the comparable organisations, ones that are set out to conduct that type of investigation, rather than the broader issues that would come before a public inquiry. And quite clearly, there are very severe restrictions. I've mentioned the ones already in the ICR in terms of its broad discretion to do light touch reviews rather than full investigations. If you look at another aspect of it, the duties around what they have to put in their reports. So under the Stormont House Agreement, there was quite a heavily codified formulation whereby there would be maximum permissible disclosure, that reports to families had to be as comprehensive as possible. All of that's been stripped out of the Legacy Act. It's quite minimal what the ICRIR will have to put in. Will have to actually put in its reports at the end of the day.
Yeah, and then the other aspect is in terms of, I mean, the insistence that there is absolutely no difference. I still find it baffling. But notwithstanding that, I mean, even the Stormont House mechanisms, so, you know, the ICIRs was envisaged alongside of the HIU and everything else. I mean, the Article 2 compliance. I just feel that because the reach of the British government using national security will ensure that or will maybe impact on an Article 2 compliant investigation. And that's the concern. And then the other aspect of it all is that Hilary Benn seems to be quite content to keep it as it is. So, you know, I heard your earlier discussion around, you don't know, you've just heard the intention. We all have heard the intention, but we haven't seen what the substantive amendments would be. So has there been any discussions around what that may look like in order to ensure that it has credibility and it has an impact?
We have a new report coming out tomorrow that will look at the issue of how you could transform the ICIR in terms of a sort of root and branch reform process that would produce something quite distinct that'll look into the individual sort of elements of it. I think both the Chief Commissioner of the ICIR and the Commissioner for Investigations at one point certainly said they would resign if the legislation was found to be ECHR incompatible, which has now happened, and that government didn't rectify that, which the intention to appeal would indicate that they're not planning on rectifying that. I would hope they would reconsider that and move forward to transform the legislation. There is sort of no do-nothing option, but I mean, if it was to continue with minor changes, that's just a recipe for constant litigation in individual cases, because one of the issues, and Grania, you mentioned it earlier on in your opening remarks, is the practical independence of the ICRIR is actually yet to be tested, because the courts had deferred that to individual cases, the circumstances of an individual case, whether the personnel and structures are sufficiently independent to be able to conduct those investigations. And if you're going to end up with just repeated legal challenges for a body that won't function and as the Council of Europe assessed, for the support for which is minimal. And I'd hope ultimately Hilary Benn will see that and will move on it to produce something that would be human rights compliant. And it's also inescapable that just as Hilary Benn has quite rightly gone back to the 2004 Western Park Agreement in relation to undischarged bilateral commitments with the Irish government on public inquiries, there is an existing bilateral agreement and a treaty sitting there in relation to the Stormont House Agreement. The treaty relates to the ICIRR, the cross-border body. It was a treaty with the Irish government, and whilst I know, and you mentioned Bill of Rights, the Bill of Rights, of course, had it been in place, it would have required codified Article 2 duties around independent, proper investigations. It would be much more difficult. It would have been easier to challenge the Legacy Act had the Bill of Rights been in place, although we still have the ECHR. But there's no escaping the fact that there is an existing agreement. And whilst there has been these implementation issues across the peace process for various rights-based measures for a long time, it's worth remembering, and it was Boris Johnson and his government who did it, this is the first time that any state party to any of the bilateral agreements of the peace settlement has just sort of waded in and unilaterally torn one of them up, which is what Boris Johnson did with the Stormont House Agreement. But it's still there. It's still an agreement, and the two states concluded a treaty, and it's inescapable. That's going to have to be returned to as a sort of baseline. Of course, it can be built on with a sort of Stormont House Agreement plus approach, including the learning from Canova, which took place in the interim. Just a more comprehensive approach.
Yeah, sorry. Sir Declan Morgan was very clear that the ICIR are independent, and he said there was a legal ruling saying that independence had been tested. You're saying that independence hasn't been tested?
Yeah, I think that's an overstatement of what the court found. The court looked at some elements of the structural independence. Remember, all the court is doing is testing, is it so bad that it actually breaches the law? There are other legitimate concerns about independence that are required to make a body function that aren't just the sort of minimum floor legal standard. But the court, the High Court, stated that because it was operating at a remove and not dealing with a particular case, there were other aspects of independence, the practical independence issue that could not be tested. So it's an overstatement, to put it mildly, to suggest that the courts have ruled on definitively on ICRIR independence.
And I think it is worth emphasising where the Court of Appeal have just found the ICRIR to be deficient, the aspects that are unlawful. Specifically, and it goes back to the point Emma made in terms of victims' confidence, the Court of Appeal has just said it's unlawful in respect of effective participation, obviously, of next of kin, and also the Secretary of State's role in relation to the disclosure of sensitive information, where obviously an inquest would have previously been required to discharge the state's obligation. So it is, of course, an overstatement, and it's also why we emphasise the caveated language of Justice Colton at first instance. You know, he was very clear, made very clear that it was at this remove, and in relying on those policies, as Amnesty but also CAJ have made clear, those policies will not render the ICRIR human rights compliant.
Thank you, Chair. Thank you.
Okay, thank you. You want to make another comment, or is that you, Carol?
No, I just wanted to say thank you to the panel.
No problem. Thank you. Claire, go ahead, please.
Thank you, Chair. Thank you, Grania, Dania, for presenting to the committee. I suppose I want to talk about reconciliation in the context of the Legacy Act and your thoughts in and around that.
Thanks, Claire. I mean, reconciliation is obviously a very important part of any transitional justice process, and there's a very significant body of international law and learning that could be drawn in around how mechanisms would be geared to achieving reconciliation. Independent and effective investigations that people trust are a very, very important part of reconciliation, particularly when incidents are contested or that the official versions of events turn out to be false. It aids reconciliation to properly investigate that. I think it's fair to say that the Legacy Act and ICAR aren't going to progress reconciliation. Sure, everyone who it's supposed to reconcile is opposed to the Legacy Act for a start. But also, I think the main reason why the word reconciliation was slipped into the title of the ICAR and the Legacy Act, because if you look at the command paper, the body had a different name. It was called the Information Recovery Body, the IRB. Now, they may have dropped that name, realising that that acronym had been previously used on this island, and it wouldn't be appropriate to have that name for a body. But it looks like the word reconciliation was added to try and entirely unsuccessfully give some sort of legal cover for the amnesty, because there's a sort of whilst the ICRIR jurisprudence would suggest amnesties are usually unlawful, there is a theoretical possibility that an amnesty might be justified in certain very narrow circumstances if it could lead to reconciliation. And it looks like what happened was that the previous government, in order to try and give some sort of legal cover to the Legacy Act, put the word reconciliation in. What struck me, and I mean, I remember when we first met the ICRIR, this being the case as well, but it also struck me when the ICRIR gave testimony to the committee, that their approach to it didn't seem particularly well thought through. I think at one point they said, well, we'll let families define it for themselves. I mean, there's a huge body of sort of international expertise and international jurisprudence. A couple of CAJ board members, Professors Anna Bryson and Professor Louise Malander, have done some quite detailed work on this in relation to both what reconciliation is in terms of international law relevant to transitional justice, but also essentially why the Legacy Act won't achieve those goals.
If I could just add, Amnesty obviously globally, we have looked at truth commissions obviously in many countries, but we have yet to see an example, far less a successful one, that has been imposed on willing stakeholders, obviously, as we see here. And I think that is a key point. I think the Act and the ICRIR, they appear to place a heavier emphasis on reconciliation and future peace rather than on exhaustive revelation of past events, and also without first providing the truth, obviously, that individual victims and society needs.
Okay. Do either of you believe that, given that it is part of their title, for whatever reason it was included, and it obviously was thoughtful if it had a previous name, do you feel then that they have a responsibility to progress those elements of reconciliation, and how, in a way, do we hold them to account in that, given that they have been empowered publicly to provide reconciliation? And as you say, there are texts and studies in relation to what this looks like and what best practices across the globe. So how do we challenge them on this so that it isn't just a word for other reasons?
I think it's going to be impossible for that body to deliver on that mandate, because the structures of the Legacy Act and the reasons it was put into place were for an agenda that is the antithesis of reconciliation. It was an agenda by the previous government of impunity. And that's why they put these mechanisms in place. And notably, the Conservative front bench is incredibly keen to keep the ICRIR, so they must be thinking that it is delivering on their agenda, and it was a mechanism set up by their Act. So I think what we're going to have to do is look at a very significant reform and transformation process as part of this repeal and replace commitment, to produce something different where that reconciliation will be at its core. Now, that could be part of an investigative body's mandate, but you're also looking at the much broader structures around what legacy mechanisms could do. The Stormont House Agreement discussions ended up with a quite significant number of mechanisms, not one sole mechanism. One of the big gaps was themes and patterns. I'd mentioned the International Expert Panel on Impunity. Their recommendation was to come up with was that the two governments should establish some sort of international commission with the UN and Council of Europe support that would pick up the individual case issues from investigative bodies and the other legal processes, and be able to work on all of the different themes and patterns that have been mentioned by members of this committee and others. And that would be the place to also ensure reconciliation.
Yeah, I suppose I agree with that, because to me, in terms of our story in Northern Ireland, reconciliation is absolutely critical. And it would concern me that a body that has been set up, it's given a title of reconciliation, it would almost be, be felt that it's ticked off in that guise, and I don't like that, So if we're being honest about what, if reconciliation is being pursued, then I think we need to recognise what this body's doing and what it's not, and if it's not doing it, as you say, then we need to pursue another route for that. So,
okay, Thank you. I just have one final question. That's really in terms of the Northern Ireland Affairs Committee. You mentioned, Grania. Whenever the chair was in Belfast, I think it was 2 Fridays ago, that she had indicated that this would be something, the Legacy Act, would be something that they'd be focused on. So what degree are you going to be working with them and engaging?
We've written to the Northern Ireland Affairs Committee
Okay.
and asked to present to the committee on this issue, so we're just waiting on a response and hopefully a date that would be given.
Yeah, we've also written to them. They're actually in town for a meeting next week, and we will engage with them on that. Yeah.
Oh, that's brilliant. Thank you so much. Go ahead, sorry, go ahead.
Very briefly, Chair, having listened to this discussion this afternoon and realised both before, during, since the Act came into being and listening to you today, there has to be a fundamental review and reversal of where we are today. What I find most disheartening, or two things I find wholly disheartening in this. One is the failure of the UK government to make good on its promise, and the other is that a former Lord Chief Justice can't understand that in any other circumstances and in his previous position, the judgments that he's pushing back against are the very judgments that he most likely would have made himself.
I think that's it. Point to end on. Okay, so thank you so much. And we've got victims. You're very welcome to stay to hear the next evidence session if you wish. Okay, members. So I think if we have a quick conversation around what we want to do, any proposed actions. I think you had come up with one. Yes.
Well, Declan Morgan, to ask for an update on
the
number of cases and the number of investigations
okay.
since September. I mean, whether or not we need to bring him back, but I think we could ask for that in writing.
Okay.
But also in terms of the court judgment, does he have proposals? Is he bringing forward proposals to make the ICRIR Article 2 compliant?
Okay.
So I think there was an onus on him and his panel.
Okay. Is everyone in agreement that we will maybe add to it? But are people in agreement that we would? Go ahead, Carol.
Yeah, I have no issue with that. I would also like, if possible, to write to the British Secretary of State, Hilary Benn, particularly around the retention of the ICIR in its current form. Just to clarify that and to clarify when consultation proper will happen around the legacy bill, how that's going to be repealed. And then even just in terms of the ICIR, how many cases thus far have they, used, or has a national security been used not to provide families with information? Because I think it's all quite important given what we've just heard from the panel. It contradicts what we heard from the ICIR, in my opinion.
Okay. I'll take Claire and then we'll go ahead, Claire.
Yeah, thank you, Chair. I suppose it's really just to pick up on the points around reconciliation. What I'm hearing there is that word was tacked on at the end to satisfy some other reason. Now, whether that's the case or not, I'm sure someone will answer to that. However, I would be concerned that we don't then have a process of reconciliation because it's deemed to be within the remit of the ICRR. So can we clarify that? Can we clarify what that means? Maybe that's writing to the Secretary of State. And if it is a limited role, are there plans to provide something more substantial? Because post-conflict society, it's something that I personally believe we need to do. Otherwise, we always risk going back. So if others are in agreement with that.
Okay, I'll just take Timothy. Go ahead.
I think on the basis of what we've heard today, we should write and invite Sir Declan back to the committee, give him an opportunity to respond to some of the comments that have been made. From memory, the last time he was here, he was pressed for time. So
it was a few days before the court judgment too, which was unfortunate.
Yeah. So I think it would be an opportune time to write to him to try and invite him back in front of the committee.
Okay, so we'll take the ICRIR first then. So are we in agreement that we would invite Sir Declan Morgan and his colleagues back before committee?
Yes. Agreed.
Agreed.
Okay. And we'll also, thanks Emma, and in the interim we will also ask for information, as Brandon outlined there, around the information, the number of cases, but also Carol's suggestion there.
Yep. And if he has any proposals for reform,
yes,
the committee agreed with that. Yep.
Okay. Right, so that's fine. And then the other one was in terms of the Secretary of State, Hilary Benn, asking for his assessment of what the consultation and the repeal and replacement of the Legacy Act will be. Did I pick you up correctly there, Carol? Yeah.
Yes, that's correct, Chair. And also to ask something specific on the ICIR, because the commentary was that he would just leave it as it is. So if we could get that confirmed in writing, that would be helpful.
Okay, and then Claire's piece around the reconciliation remit.
I think, Chair, it's important too that in writing to the Secretary of State, we both draw his attention to this discussion today, and also the tenor of this, that there's unanimity among this group that remains over the Act, and an urgent desire to see him fulfil his manifesto promises.
Okay, thank you. Okay, we'll move on. Members, thank you for that. So we're going to move on to our next oral evidence session, and this is with stakeholder groups. So we have got Alan Brecknell from the Pat Finucane Centre, we have Sandra Peake from Wave Trauma Centre, and I believe we're going to have Kenny Donaldson will be joining online from the South East Fermanagh Foundation, say via Zoom, so hopefully he'll be up in a couple of seconds. But you're very welcome to committee. Thank you very much for giving us your time today. Are you going to make some, just before I bring you in, Kenny, I know you're very busy today. Are you pressed for time, or?
Yeah, well, absolutely fine, sure.
Okay, no problem, thank you. Okay, so I'll go to the people in the room first, and then I'll bring you in, Kenny. So, Sandra, do you have any opening remarks you'd like to make?
Yes, thank you.
Thank you.
Thank you, Chair, and thank you, Committee, for inviting me to give evidence this afternoon on behalf of WAVE, which many of you know is a regional NGO working across Northern Ireland and further afield in response to need with victims and survivors of the conflict. I mean, a 10-year strategy which has been unveiled is much needed, and we do not see work with victims and survivors of the Troubles diminishing. In fact, far from it. Since COVID, the numbers of new referrals into WAVE have doubled. Now, I do believe there are three central reasons for this: the Legacy Act and the outworkings of the government, particularly from November 2020, really brought a lot of uncertainty, brought a lot of distress, and brought trauma very much to the fore in relation to victims and survivors. And we would have seen rising referrals of people bereaved and people back into service provision that had left us some time ago. So there's no doubt that legacy is a central issue that affects service provision today. The second thing that has brought a lot of individuals into services is the Troubles Permanent Disablement Payment Scheme, otherwise known, and we would have called it in WAVE as the injured pension. And that's brought a lot of people into service provision that have never been in service provision before. However, correspondingly, there's also an adverse impact on those bereaved, because if you cannot demonstrate proximity to the incident, and some bereaved can't, well then you automatically are unable to apply for that programme. And correspondingly, we would see a fundamental need for further work to happen in relation to acknowledgement of those bereaved, because there's an inherent unfairness. There's also an inherent unfairness in relation to the South for those who've been injured there. But I appreciate that's not within your call here. And finally, the other issue that's brought a lot of people to the fore has been COVID, because it's been so damaging to mental health. And I think that what we would have seen throughout COVID, and indeed since, because referrals have not diminished, is that the past came back to bite, and bite hard through COVID, because people's jobs, hobbies, family, they were rendered into a very isolated state. And for many people, they really struggled with that. But the past came back to visit them, and we would have seen rising referrals, not only here, but actually from people who had left these shores, who were living in Canada, in Australia, New Zealand, wanting actually to access services from here. So international referrals rose from people who had left here. The legacy of the Troubles has left a deep and indelible legacy. Individuals continue to be affected by it and affected by it today. And I think that we need to ensure that service provision is provided, and obviously the committee have a very clear role in relation to the oversight of the strategy. And we need to ensure that there's accredited services and therapeutic provision, and advocacy is key, but there's also budgetary requirements in relation to a 10-year strategy. And I suppose that's really one of the messages I wanted to say to you today. A 10-year strategy is important because we need to have firm and support and therapeutic provision for families coming through. I think the other difficulties that we would have seen, the problems of not addressing the past, and when we have undertaken ongoing work with families, is that we're handing trauma to the next generation. That's clearly evident. You know, you can see the next generation taking on the injustice of the past, taking on their loved ones' cases. I'm delighted that you mentioned bringing the Independent Commission for Location of Victims' Remains to present, and I've worked with those families since the mid-90s. And for those families, you can see the next generation have been given the mantle of responsibility to find their loved ones. So it's not diminishing. So trauma has been handed to the next generation. When the government proposed an amnesty and limitations, it suggested the state were no longer interested in their case. And fundamentally, that was very damaging at a psychological level, because people really felt that their deaths were just being pushed to the side. Their loved ones' loss was not being recognised, and that really was very harmful. The third is that by not addressing the past, we undermine the rule of law, and that's a very big issue for families, particularly when they see those responsible for murdering their loved ones, that they'll never be held to account. And today there are families who continue to be winked at, sneered at and smiled at by those who took their loved ones or killed their loved ones. So we're not dealing in a society. The intimacy of violence in many communities continues to be felt, and we have to be very mindful of that. And the final thing is it's about equality. Pat and Linda Malloy's young son John was walking home one night when he was stabbed to death. No one was held to account. Police investigation never moved beyond that day. And Linda Malloy will rightly ask, what is the difference in the death of her young son on the streets of North Belfast and the case of Stephen Lawrence in London, who was stabbed because of race? Why are they being treated differently? And that was a fundamental issue about the inadequacy of legacy proposed. So we must have a process that gives families full investigations. We must have a process that has all the rigours of criminal justice investigations, and we can't allow families to be given anything less because it's so wrong. And so therefore I urge you to do whatever you can to ensure that we keep the issue of legacy to the fore, because it's very damaging for our future if it's not addressed. Thank you.
Thank you, Sandra. I think I'll just take all the contributions and then we'll come to questions. So do you want to go ahead, Alan? And thank you.
And thank you for the opportunity to give witness testimony here today. It's not something I'm used to doing, so I have to admit I am feeling a bit nervous here. So the Pat Finucane Centre works with a large number of victims and survivors across both communities. Most people will probably find or think that that's unusual, but it is the case. It is, to be honest, obviously mostly within the nationalist community, but there are a small number of people from within the unionist community that we have worked with and we do work with. We work with people from across the two islands. Justice for the Forgotten, the campaigning group for the Dublin and Monaghan families, is part of the Pat Finucane Centre now. Strangely enough, funded through the Department of Foreign Affairs, but that's another issue. So I suppose we would deal more exclusively with advocacy as opposed to health and well-being issues. So obviously the introduction of the Legacy Act had a huge impact on the families that we work with. It cut off for an awful lot of people. The 1st of May was actually, and I don't say this lightly, a traumatic event for a lot of people. We had people who were going through the inquest system, we had people who had civil cases, we had people going through the legacy investigation branch of the PSNI. There are people who have complaints with the police ombudsman that have been sitting there for over 10 years or so. All of those things finished all of those options were closed to those families. And it seemed like a really arbitrary date for people, and why. And as Sandra has already pointed out here, it created nearly a two-tier system as to why should someone who gets stabbed or killed in an ordinary crime, so to speak, be treated any differently to someone who is connected to a troubles-related crime. So I suppose that's partly why we're very engaged in the whole process around what the ICRIR is and isn't, what it can do and what it can't do. And we take our lead from the victims and survivors that we work with. We will do as much as we can to find out what is possible, what isn't possible, impart that information to the people that we work for and along with and advocate for. But at the end of the day, it's their decision. And what we are hearing back from the people that we are working with is that this body will not work for them. It will not get the answers that they are waiting for, some of them for over 50 years. And I think we need to put into the context the age profile of victims and survivors. My mother is 91. She lost her husband in 1975. That's a long time ago for someone to wait for answers, and she's just one person. That is replicated across all communities here. And I think, as and listening to the earlier contributions as well, we don't have time on our side here, and we don't have time for another British government to draw things out further and further and further and further down the line. There are options that can be brought forward and should be brought forward as quickly as possible to remedy some of the wrongs of the Legacy Act. We can't do it all immediately, but the timescales that we're being told is the summer of next year for even remedial orders to be put in place. And how long does it take then to get things operational and up and running again? Like, there's a number of families, as I say, we've worked with who are going through the inquest process and thought they were going to meet the 1st of May and didn't. And then there are others who were granted inquests just before the 1st of May. And what happens in those situations? So there's lots of issues out there for people. So I'll leave it at that and answer any questions that I can.
Thank you, Ellen. Kenny, do you want to go ahead, please? Thanks.
Yeah. Thanks, Chair. And I suppose firstly just to say that I could associate myself with a significant amount of commentary that's already been made there. So I'll try and steer away from that and move into other areas that haven't been spoken of. South East Fermanagh Foundation, SEF, is who I'm director of, and we're 26 years in operation. We provide services across Northern Ireland, the Republic of Ireland, and Great Britain. And guys have touched on values and in terms of who we support. Again, it might come as some surprise to folks, but we would have a very diverse user group at this stage. Growing from a traditional base of predominantly people from a Protestant Unionist tradition background, but those who access our services now are all connected by their shared value system, that all of the violence was wrong, irrespective of whom carried that violence out, and that's how we define. Sandra has quite rightly spoke of the TPDPS and also the Legacy Act, and indeed the Regional Trauma Network as those push points for additional referrals into the system and what we're dealing with. For us as well, peripheral-based victims and survivors is a significant change factor in the last 7 years from the last funding round of 2017. And I suppose I want to touch on that particular matter of where we were as groups in 2017 and where we are in 2024. It's not comparing apples with apples, it's comparing apples with damsons, because it's a huge change. There's been so many developments within the sector which are not reflected in the victim and survivor strategy of 2009 to 2019, which is now obviously 5 years out of date. There have been some really positive developments that have happened in more recent years, and we should take a great deal of positivity around that. And other things, just as is the case in Northern Ireland, haven't moved forward so much at all. I think in touching on the legacy related issue, and obviously there was a universal opposition to the proposal when it first came across victim and survivor groups. But in some ways it was an unholy alliance of opposition, because whilst we were agreed of what we opposed, having agreement around what would replace it is a much trickier issue. But from our perspective as an organisation, we are not blockers. Never have we sought to deny people from across our community pathways and rights to pursue justice, truth and accountability. That includes the civil litigation process and also the coronial inquest process. But there also must be pathways for others whom are not facilitated through those two structures, predominantly as those who have been impacted by terrorism. There are limited opportunities through those processes. Can I say as well that this comes down to a choice, I think, and finances are obviously very precious at the moment, and we recognise that right across government. What it all comes down to is, do we want a Rolls-Royce service for victims and survivors in Northern Ireland, or are we going to have to carry on with a decent VW Passat service? Because that's what this comes down to. It's about resourcing, and it's about whether or not there is the prioritisation to be given to this matter to actually take it through into a different stage on a different level. As an organisation as well, I suppose we have increasingly ceased to use language of justice, because justice in the context of this place has been all but murdered already. But what we do need is accountability, and there must be accountability across the board from all concerned if we're going to have a truly strong base in which to build a new future from, and moving away from the denials that we have so rife across the society in all quarters. So that's where we come from in this. So I think the strategy offers the opportunity, Chair, to refresh, to update, but to refocus all of our efforts going forward. And we have a huge job of work going forward into the future, not alone in serving those being impacted by the violence of pre-1998. We also need to be aware that new victims have been created in more recent times. And one particular example I would quote is our work with school children connected to Omagh High School in the aftermath of the attempted murder of DCI John Colwell. That was 14 young people who were not ever expecting to be in a position where they were ever going to witness such an act. So we do need to be very aware of all of that, but just as has been said by our other contributors today, Sandra, and there is certainly a wish in us all that we would do better by victims and survivors, and certainly that first generation victims and survivors would have some release before they pass this life, that things have been done right by them, and better late than never.
Okay, thank you all. So I just want to pick up on the issue of the new victims and survivors of the Troubles strategy. So Kenny, you mentioned a bit of it there, and I think Sandra, you did as well, that it's welcome. It's 10 years, so there is a duration to it. But just if you could highlight some of the concerns, and also the speak to the resources that you as frontline organisations have received or have been promised, and certainly Alan, if you want to contribute to that as well. Do you want to go ahead, Sandra?
Sure. So I think the strategy usefully looks at needs and focuses with the first pillar in relation to the needs presented, and then the second looks at the past, because there's no doubt the past continues to impact upon the needs presented. And I think to look at either, you need to look at them side by side, because they both have a corresponding effect. So the strategy does set out in relation to the provision of services and a complex range of services to meet needs. As Kenny said, I think one of the fundamental difficulties is around the budgeting in 2017 and how that relates to the presentation of need today. And as I said, WAVE would have always averaged around 650 new referrals over years. But once COVID hit, then it doubled, and there's a big issue, and we don't take everybody who's referred into us, and that causes huge issues for our team in not doing that, but quite simply we're not able to do that. So there is a need in relation to ensuring adequate service provision is in place, and also as well, like we have ongoing investigative processes that have worked. Operation Canova, I believe, was the best example of dealing with the legacy of the past. But out of Operation Canova came very clear advocacy needs, but also very clear service needs in terms of taking those families through. But we believe that fundamentally was the best model, that certainly in my time in Wave that I've seen in relation to addressing the legacy of the past. And I would urge you to hear from Canova in relation to the central tenets of why they had such success. Because when families came in relation to Canova, we asked them where their trust and confidence was, what they wanted to achieve, and they had no trust. They had no confidence in what they were going to achieve, and they felt that John Boucher, who was had been appointed then by PSNI, would never uncover anything and would protect in relation to information that was there, and that quite simply wasn't the case. So those type of investigative processes have a direct impact on services and on the budget required in relation to providing those services. The other example coming up now will be the Omagh inquiry and what that will do in relation to the community in Omagh and those who are further afield who are impacted by Omagh, who again will need support service provision. Okay. So I think that there needs to be a clear move in relation from a strategy perspective in relation to ensuring that there's adequate budget there to meet the presenting needs today. Because in a way, as a society, we've dealt with this through silence. Silence all over the years when you think of lack of statutory services, statutory service provision. And now what we're seeing is a growing number of people who require the support services that are offered across the sector.
Okay, thank you. I'll take you next. Kenny, do you want to talk to the strategy, good, bad and indifferent? Thank you.
Surely. Well, Chair, I suppose what I would start off with is that for me, the missing ingredient in psychology around all of this is that victims and survivors is a cross-cutting theme of government and should be considered as such. So when there are areas touched within the strategy which particularly pertain to health, or indeed the glaze around the area of education in terms of troubles-themed education within schooling system and curricula, that's all fine and well, those kind of references being made, but ultimately there needs to then be resources derived through those departments in order to top up the abilities to do that with victims and survivors, because it won't be able to be done on a frozen budget of 2017 going forward into the future. And we are very aware, in fairness, that the victim and survivor budget was frozen at least, and didn't receive any sort of cut as other areas of government have. But we're just being realistic here that if there is a will to genuinely move into those other areas, which I feel is required at this stage, then it costs resources, and it has got to be a commitment and a realistic around what's needed. We have experienced from 2017 our groups continual pressures. TPTPS, when that particular scheme was developed, approximately 50 to 60% of the intake thus far who have been supported have come from within the group family of victim survivors, if you want to call it that, but 40% came from left field. And those folks have never been involved with victim survivor services down the years. They are now requiring supports through health and well-being, through advocacy, through wider welfare, and a whole range of other supports. Similarly, whenever the regional trauma network has formed, there's a new intake in terms of referral coming through all its various sections. So that has come on top of what the existing pressures were, but there aren't additional resources to deal with any of that. And Sandra said you're left then in a really difficult predicament. Our ethos, our burning desires groups, is to support each and every person who comes to that door and who requires that assistance. That's what we should be here for. But we're almost getting into a position now where we're into our own form of hierarchy of victim in terms of the prioritization of services for people, and that's not a good place to be.
Thank you. Kenny, do you have any comments, Alan, on that?
Yeah, I think one of the comments that I would make about the strategy is that it's quite open-ended. It's and I don't say that as a criticism. I actually think that's quite a good idea. It allows for flexibility. We have found over the last 15 years of the strategy that we've just had that victims and survivors needs change. As I've already pointed out, the age profile, so that will change. Things have come up across that period of time that we didn't envisage, we didn't know were going to happen. Kenny's already pointed out that things have happened that we weren't expecting to happen in relation to to attacks on police officers and whatever in more recent times. So I think from that point of view, it's encouraging that there is flexibility there, and if with that level of flexibility, I think different programs can be broadened out and brought forward across that period of time. I think one of the other things that is maybe missing, and is definitely missing out of this, is there doesn't appear to be any mention of a bereavement acknowledgement payment. Something that has caused huge difficulties within the people who would be classed as bereaved, as opposed to those who are physically or psychologically injured. And I use the word acknowledgement payment on purpose there. It's not compensation. It's not, oh, here's a handout for you. It's to acknowledge what actually happened to people, that some part of their life has changed because of the actions of someone else. So I think that would be important, that more work is done in relation to that. And I note that the last Victims Commissioner, one of the last acts before he left was to give a paper to the executive in relation to a bereavement payment. I have heard nothing about it since, to be perfectly honest with you. I think one of the other things, and funding has been mentioned there, and I don't want to go on about funding, but the funding strategies that are currently in place are all out of sync. We have a strategy that's going to run into 2034. We have Peace Plus, which provides both advocacy support and health and wellbeing support, which will run out in June of 2028. So what happens in the intervening, or the period after that? VSP, I'm not sure what the funding strategy is there. And if a body like the ICIR or whatever takes place, it is to run for 5 years. So assuming it was to start and do its work and was accepted by the vast majority of victims and survivors, which it currently isn't at the minute, it would finish its work by 2029, which is after the period of time that the likes of health and wellbeing support is available, and advocacy support. So I think there are things there that can be looked at and can be worked upon within the strategy.
Okay, thank you. I suppose since I've moved into the Executive Office sort of role for the party, there are a lot of really, really good organisations out there, and have been for many years, delivering services, and you do seem to work very well together, and not necessarily keeping your own swim lane, but you do complement each other. And I was struck by the suggestion within the strategy of a designated public space of reflection. How manageable do you think that will be in terms of getting agreement and getting, again, it might be might be a main location plus some sort of regional complementary sites. So how realistic do you think that will be in terms of delivering? And was that something any of the three of you actually suggested as part of the consultation on the development of the strategy?
I mean, I think it's an interesting area, and I think that the more that we can provide acknowledgement for what happened in the past, yes, to ensure that we don't repeat the mistakes of the past, I think is very welcome. I think the Day of Reflection on the 21st of June, we have, I suppose, had acknowledgement events for that on an ongoing basis, and families very much use that day as a way of remembering who their loved ones were, yes, and what they were like, and of course every day is an anniversary for someone, including Christmas Day. So whatever we can do, I think, as a community, as a society, to ensure there's recognition in relation. That's something which is very important, because as a society I don't think we've been overly good at that. And I think, yes, there are examples, Chair, of initiatives, but that Day of Reflection should be right across. It should be held here. It should be absolutely everywhere, and there should be broad recognition. Next week we will have a Tree of Lights and Wave, and an event where families come, share poetry, share music, and that's an outdoor event with lights across the trees. To remember all those who died. And I think whatever we can do, we need to do in relation to ensuring there's that acknowledgement and recognition.
Okay, any thoughts on that, Alan?
Yeah, I think we may have difficulties with a particular space, okay, that people will agree on. We all know the huge difficulties that there are around the definition of a victim, and how some people accept it, other people don't accept it. I accept that it's a very broad definition, to ensure that no one gets missed, that needs to be helped and supported. And I think that's what's important about the definition that we currently have, that it ensures that whoever has needs from the period of the Troubles, the period of the conflict, that they are met, and they are met by this society, and they are met by the government here. One of the things that is really important is to make the point that not one department should be involved in victim and survivor issues. It should be cross-departmental. Every victim and survivor here is a member of this community. Therefore, the response to their needs to be from everyone within this community and across every governmental department. Again, we do an awful lot of work with individual families to do memorialisation. Not everyone wants a big space where they can go to and sit and reflect and whatever. They're quite happy to have their own space to reflect and remember who the individual is. And some of the stuff that we've been involved in is planting trees where people like to go to, a park bench, where those sorts of things, they don't seem significant in the wider scale of things, but for individual families they are. Other things that we've been involved in is helping people pull together publications about who the individual was, or video reflections. So they're there for the generations to come that remember who that individual was, who remember their personality, that they're not just a statistic, they're not a number in lost lives, and then obviously there's people who have died since who are not in lost lives. So I think we need to be more compassionate about how we deal with these things, and we're not always good at compassion. And it brings you along towards reconciliation and the notion of reconciliation. And I heard the conversations earlier. We can't be forced to reconcile with each other. That's something that happens.
And that was sort of I was thinking about, the sort of the maturity over the years and the working together.
And it does take acknowledgement, and we do have to acknowledge the pain and the hurt that's been caused. But within that word acknowledgement is the word knowledge, and we need to know what actually happened. We need to know what happened to individual victims and survivors, to communities, and that's where dealing with the legacy of the past is really, really important. It's not a side issue. It's not something that should be swept under the carpet and we'll talk about that whenever it just keeps getting pushed down the line, put in the too hard to do tray. And if we continue to do that, we're just going to pass it to another generation and a generation after that, and it should be stopping at this generation.
Thank you. Kenny, have you any thoughts on that proposal? Please.
I think it's one, Chair, that does have to be tread very carefully with, and the key question that I think that your committee and others need to ask is it about preservation of ideology? Is it about creating a cash cow in terms of finance via tourism, or is it actually about people and relationships and trying to aid the process of healing for such individuals? And that in many ways will determine the approach that is used. And of course, the location is also. But I think in terms of, saw it in different parts of the world where it's been done well, and then in other parts where it has been less so. In this society, there are localized examples of where memorialisation, I think, has been done in a very fitting and inclusive way. And then sadly, in other situations, that's not the case. And we do have a significant number, obviously, of illegal type structures across the country as well, which is very, very challenging, particularly whenever that's in shared public spaces. And that's an area that has still to be dealt with. The Flags and Emblems Committee, which examined a lot of issues in the Belfast context, it didn't cover so much into those other areas, which is front and centre of mines and borderland areas and in other parts of the country. So it is a very, very sensitive issue, this. But I would suggest that whoever is seeking to engage in that debate needs to come at it from the point of view of the victim and survivor who's being impacted, and not for either of those other two reasons.
Thank you, Kenny. Deputy Chair, with your indulgence, I'm going to ask Brian, because Brian has to leave shortly. Do you want to go ahead?
Thank you, Chair, and I apologise, I have to go about 10 to. Yes. Just have an online meeting I need to attend, but thank you for your attendance today and for the work, Kenny, also that you're all involved in. Just referencing our earlier session, can you feedback, obviously not in any individual cases, but are you aware of people who have engaged with the ICRIR? What feedback have you received on that?
and also we were discussing earlier with the new Labour government, talk about consultation, which I don't think anything has commenced yet, but have you any views on if there is to be consultation on new and better ways forward? How should that consultation best take place?
As an organisation, we will go where families go. So if families ask us to support them, we will. So we have a small number of families who have gone. And they've gone really for a variety of reasons around their own health outcomes, and I suppose around the concept, and Alan said it, around time. Feeling that they haven't time. Time's not on their side. It's very early in terms of knowing really how that will go, and I think there's a real sense of internal battlement in relation to whether they should go or not go in terms of what it's going to produce. So I think that time will tell. I think the unfortunate thing is that the suggestion from the government is give it a go and see how it goes, and that is grossly unfair. Because if it's not right and it's not fundamental and doesn't have the transparency, independence, or the systems and processes that we want, or the powers that Canova had to give families what they received, then we're selling victims and survivors well short. So I think that to give you a full answer, and I think that's very difficult to say fully. And I think this sense that in some ways it's right to just give it a go, is totally wrong.
Thank you.
Kenny, do you want to go ahead, please?
Yes, not dissimilar in a sense, Chair, in that we would have a small number of people who have also indicated their wishes to engage with it at this stage, and none of us who are in place to serve as personnel within groups have the right or the veto to stop people from doing that. We can only provide our analysis as organisations, and ultimately if a victim survivor for their own reasons feels that they do need to engage at this point, then we are duty bound to do so. That's what we will do. I suppose it's difficult to give an assessment of where it's going presently. Certainly you will get the impression that there's courtesy, there's respect, yes, there is a will to engage, and particularly I suppose because the numbers are so small that have gone through at the moment, there almost can be a form of Rolls Royce treatment given. You don't have to spread the load so thinly, but ultimately it's outcomes that all of us are concerned about. And what will the outcomes be for victims and survivors? And any suite of legacy proposals that we sign up to at this point must deliver better outcomes than have been delivered in previous processes. Or what on earth are we doing for? Putting people through an unnecessary heartache. So I think the jury's out on it to date, but there are some people who are tinkering with whether to engage with the structure.
Yeah, in relation to whether people have engaged with the ICRIR or not at this stage, I'm not aware of any of the families that we work with who have or who are intending to. And as I said at the start, that's their choice. And we will take our lead from them. What we can do is, as Kenny's already suggested, is we can outlay what the pluses, the minuses, what's out there, what's available, what's not available from that process. I think Sandra made the point about Operation Canova, and I suppose most people talk about and it being the gold standard of what can be done for legacy and relation to legacy and whatever. I think the point should be made and should be acknowledged that Operation Canova was an investigation. So it had policing powers. It had all the things that any current police investigation would have. So why would you be offering anything less to anyone else? I think that we need to remember that. People throw that term out there very glibly saying, oh yeah, Operation Canova-esque. No, but it's not Operation Canova-esque. It is what it is. It is what it says on the tin, and we need to remember that. In relation to the consultation that's being discussed, I think one of the questions I would ask, what are we consulting on? We don't know what we're consulting on. We don't know what the proposals from the current government are, because, to me, repeal and replace, it's fairly definitive. It means do away with it and put something else in its place. Whereas what seems to be suggested is that we'll do away with bits of it and we'll keep bits of it, and we're not sure how those bits that we're keeping are actually going to work yet, because we don't know, and the courts have now told us that you don't know. So there's that in relation to consultation, and are people not consulted out at this stage? Yeah. And after Stormont House Agreement, there were 17,000 plus responses to that consultation. The vast majority were in favour. I think we had a process within Stormont House Agreement, and it was already alluded to in the earlier sessions, that we could have worked on, and Stormont House Agreement Plus could have worked, because there is learning from Canova that could have been fed into any process. The other thing I would say about Stormont House was there were two separate bodies. There was the HIU and there was the ICIR, the Information Recovery Body, and now we seem to have lumped the whole lot together, and I would say they need to be separated again for the reason, if someone's coming forward to the ICIR and giving some form of information, well, that needs to be checked, it needs to be verified. There has to be an investigative body that is separate from that body to check what someone is saying, that it's not about, well, this is justification for what I did and what the organisation I was involved in did and whatever. And so I think they need to be kept very, very separate.
Okay, that's a good point. Is that you?
Thank you.
Thank you. Go ahead, please, Stuart.
Thank you, Chair. Thank you, everyone, for your contributions. And it's hard listening to you to not think about individuals that I've known through my lifetime who are victims, and those that have been traumatised by all of the events of the period that we went through. And this question is really about, well, a couple of people that I'm thinking of, but specifically just about the type of services which you, rather than give an individual case, just to think about the type of services which you all deliver. And I appreciate that, as Sandra said, sometimes it's Christmas, it's anniversaries, and for some people it's an anniversary every day. And it's really in the space of, for those for whom it's an anniversary every day, how much more difficult is that made for them when no outcome, there's been no judicial outcome, in fact no arrest of the person who was the perpetrator of the offence, and yet the family have to live in close proximity to that perpetrator all of the time?
I'll bring Kenny in first. Go ahead, Kenny, please.
Yes, good question. So, absolutely. Look, whenever something evil happens in the world and there isn't resolution and there isn't any outcome, that injustice remains. It hasn't gone anywhere. And for so many within Northern Ireland, that is the case and beyond, the linked events to here. So it's extremely difficult. And I would say as well that, and this isn't to diminish in any shape or form, an urban experience, but often people live in ghettoised circumstances within our urban heartlands. You live in rural parts of Northern Ireland, you're living cheek by jowl together.
Yes.
And in many ways, the levels then of distrust, paranoia, are at a fever pitch level in those areas, because people are literally coming into contact day and daily with individuals whom are believed to have been involved in some shape or form with a crime.
Mm-hmm.
And that's extremely difficult to actually to see by and to come through. So there absolutely is a need in this society for our people to be humbled across the board.
Yeah.
Pride and the lies need to end across the communities around what actually happened and the gravity of all of that, because there will never be a proper Northern Ireland forged ahead. There will not be what we consider to be real peace, not standoff peace, but a real integrated peace, unless we're realistic about what needs to be done. And nobody gets off lightly in this. There's accountability needed across the board on all of it. And we would really, see that as first and foremost, Chair, a necessity. Otherwise, we're going to look forward. We're going to continue to put on sticking plasters on events, and we're going to get nowhere. And when we talk about how we deal as well with the legacy of the past and Stormont House, Stormont House had a foundation, perhaps, but the problem with Stormont House was we're not two states at the races. There was an abdication of responsibility on the part of the Irish state to that process, which meant that there was never going to be a balanced outcome to it. And had people grasped the nettle at that stage, then perhaps there could be something done in terms of developments. We're now all these years on, and ironically, now the Irish are talking about some of the measures that we would have suggested were necessary at that stage in order to build full confidence and support. So I think people need to just get realistic around what needs to be done, the hard miles that have to be travelled now if we're going to have the type of country that we want, or we're going to continue to exist in this place where we're together but separate.
Thank you. Alan, do you want to respond as well?
A difficult question, definitely. There are large numbers of people out there who there have been no judicial processes for. There are also large number of people where judicial processes have started and were never completed. It is a small place, so obviously everyone knows everyone, and we all know or believe we know who was involved in X, Y, and Z and whatever, So that is a really, really difficult place for people to be. I do think I agree with Kenny. We need to deal with this. We can't, and as I said earlier, we can't allow this to carry on to another generation after this. Look, this is my terminology. It was a dirty war. It really was. It wasn't. There were wrongs, not rights. There were wrongs on all sides. It's not a black and white issue. There are various shades of grey and whatever in between, however you want to look at it. To come back to Kenny's point about the Stormont House Agreement and it not being a level playing field, we advocated from the very, very start that there should be a HIU in the South as well, or a similar type body. Even just from a practical point of view, if questions are being asked from whatever that body is in the North, someone in the South has to answer those questions, and vice versa. So why would you not have put in place a body from the very, very start that would facilitate that? So there are huge issues. I don't get away from that. There are huge issues, but I come back to my point earlier. We need to deal with this now. We can't keep pushing it down the road. It's not fair on the next generation or the generations to come after that. We've created enough hurt and pain over this last 40, 50 years, maybe longer, to do us for generations to come.
Okay, Sandra, please.
Maybe just before Sandra comes in,
just
to say, and the grief of someone whose, in this case, son was murdered, that they're re-traumatised on a daily basis by living beside their neighbours, and unfortunately also getting the support of the perpetrator's close-knit community as well. But a refusal to move away from that is also a very difficult situation.
Andrew?
I think that that one of the issues that's seldom talked about is intra-community violence. Yes. And that's a huge issue here. It's an issue in the border, and I would know the border well because my family were from it. But there's an intimacy to violence, and the intimacy to violence is re-traumatising. It can be day and daily. If you've somebody who's winking and smiling at you when they see you, and you know that they're not winking and smiling at you because they're glad to see you, but they want you to know they're still there, that's horrific in 2024. And that's why Canova was interesting, but Canova was exactly about that. It was about intra-community violence. It was about what had happened in people's communities, and often they were faced with people. And when I asked one of the families recently, what did Canova do for you? And she said, knowledge gave me power. It gave me the power back because I had the knowledge. Why did she have the knowledge? It was a full criminal investigation. I had sat with some of those families through RUC investigations. I had sat with them in HET investigations. The Canova process was night and day in comparison with those. Really was night and day. So knowledge was power. That's hugely beneficial for someone who's experienced such complex trauma on an ongoing basis. The other thing they said was it gave them back their father, because their father had been demonised, labelled, had been pushed in, and that when your loved one's killed at the hands of your own community, the support is not there in comparison to whether they were killed in a car accident, died of cancer, or indeed died because the opposing side has shot them. So there's no doubt that I think that goes to the heart of what we need to do for families. Give them back the power, give them the knowledge, let them see that a full investigation. Families are not unrealistic about whether they'll ever get to court. And that's often quoted, well, it's too expensive, or it's this, or it's that. We need to have a special troubles related court. We need to have cases that are expedited through. There needs to be better resourcing into the PPS to ensure if cases ever come. And that's maybe only for a number of cases that ever will come. Yeah. But more than that, families need to have a full, proper investigation.
Thank you.
Okay, thank you. Claire, please, online. Thank you.
Thank you, Chair, and thank you, everyone. I really appreciate what you all do. I think you're providing a service that the government never has and doesn't seem minded to provide in relation to post-conflict trauma. And I suppose I'm really interested in the area of trauma, and always quite find it incredible that as a post-conflict society, we've never really had a defined public process in relation to that trauma. And I agree that other aspects of life, whether it's the pandemic, it's certainly re-traumatizing people, and it's bringing up those old wounds, if you like. And I certainly think we're at a point in time as well past the conflict where the generation that's lived through it directly, they're at a point in their lives where they're retired, where their families have grown up and moved away. So I suppose that time to reflect and look back on their lives, is very much causing particular issues now, and from a constituency office perspective, we see this quite regularly, and we see that 100% it's being passed on to the next generations, and I think our government and the UK government and even the Irish government have neglected it, to the point that I nearly feel, do we need legislation to compel them to actually recognise that we are a traumatised society, and until we fully address it in a fulsome way, whether that's through services, fully funded services, or anything else. So I suppose, given your experience and given your work and doing the job that government is not doing, what do you feel that we need to do so that we can actually get to that place? And, I appreciate the comments even around reconciliation. We always talk about truth and reconciliation, but I nearly feel we need to talk about truth, trauma and reconciliation, because until we acknowledge the damage that has been done, genuinely are we going to move forward? Because we see it coming up when people are re-triggered, and I'm really quite passionate about needing to address this in a way that I don't think has ever been done before.
Alan, do you want to start, please? Thank you. Thanks, Claire.
Yeah, look, I've already alluded to the fact that we are a traumatised society. I don't think we can get away from that, and I think, sorry to keep coming back to the same things, but until we deal with the legacy of the trauma, and the legacy of our past, that trauma is still going to be there. We have to acknowledge what actually happened to people. We have to put in place a process that acknowledges what happened to people. We have to be more compassionate towards each other. I think it's an absolutely terrible thing to hear Sandra talk about people meeting people in the sick and winking and nodding at them and whatever. We're, God almighty, we're a Western democracy, are supposed to be. We're supposed to be people from a Christian background, by and large, most of us, and how is that any way to be treating anyone? I think it's just about compassion. It's about humanity. It's about starting to learn to live with the other, if that's the terminology we like to use or not like to use. Sometimes I get really, really frustrated whenever we have these circular conversations that just seem to go on and on and on, and we talk about it, but there's no outcome to it. And I've never thought of legislating for acknowledging trauma. I don't know, Claire, how you would even start to do that, but I think what is important is that we start to acknowledge the pain and the hurt that we've caused to each other in the society, and this notion that one side is right and another side is wrong. We need to get away from that. This is 2024. We're whatever number of years after the Good Friday Belfast Agreement now. You know, we need to wise up and grow up, to be perfectly honest with you.
Go ahead, Sandra.
I mean, I think fundamentally, Claire, I mean, this should have been a public health strategy. It should have been something that was in all aspects of our society, and it wasn't. And I trained as a nurse in the Royal Victoria Hospital and worked there and staffed in theatres. And it was always interesting for me that we looked at the care of every ethnic minority under the sun, but we never looked at the fact that most nurses were coming in from segregated schooling and were coming into a system with no acknowledgement that we were nursing in the Royal, which was receiving so much in relation to the aftermath of the Troubles and did so much pioneering work. So we looked at whether or not how we as an organisation could help the next generation of nurses, social workers, doctors, counsellors, teachers. And we have a really innovative project, and if I can leave you with anything, that's, you know, there's so much positivity going on right across the sector in terms of what all groups are doing. But for us, it's around the fact that we have a group of people who are known as citizenship educators. There's over 50 of them. They're bereaved and they're injured, and they go into our medical programmes, they go into our nursing programmes, they go into our social work programmes, and they, in terms of, share their knowledge about why we need to have sensitive and responsive practice, given so much of what's happened in the Troubles is hidden, and people were silenced, and maybe in some cases continue to be silenced. So how do we get beyond that? And that's about using something which is so destructive, so negative, but they're using it for positive end. They were in medicine in May time, and the GMC, the General Medical Council, were in to listen to the lecture. And then, and my colleague Grania McKenna does a really fabulous exercise around showing that what one murder may actually mean in terms of the span of people involved in it. So therefore, why is it that we need to think about our frontline responders, or, you know, our ambulance personnel, all the various people who will deal with trauma, and we need to think about what they've gone through then, but also what they may still go through. And the GMC reviewed that as one of the most innovative areas of practice that they've seen, because they sat in and listened to testimony, and they heard the student doctors engaging, and they heard the challenges back. And now they want to look at that model, can it be replicated to other areas? That is about acknowledging the unique place this place has, the unique story we have, and the unique, I suppose, way that we can influence practice. So whilst there's so much around legacy that's not as good as it should be, there are other aspects of legacy where people are using that legacy to ensure the next generation get a better service. And if you wanted ever to hear from those educators, they would be more than delighted to tell you about their experience of being in those groups.
Thank you, Kenny. Do you want to respond to that as well, please?
Yes, maybe, Chair, just with a similar theme. I think sometimes when it goes unreported, but I stand by the following comment that the most courageous and heroic people that are within the society are victims and survivors. And the manner in which they actually conduct themselves, their dignity, their absolute resolve to want to build a better future here. They're not anti-peace, but they're anti-fake peace. And 26 years on, we do not have an integrated peace in Northern Ireland. And we need to be absolutely honest about that and what are the reasons why we don't have that. I look to the examples of people. There's a family down on the border in Fermanagh where when their loved one, there's a milestone anniversary, the very simple act of when they are remembering their loved one within the public domain, they reference two other young men who were murdered the day following. Nobody is forcing them to do that. They are choosing to do so because they are wanting to send a message that all violence is wrong. The T-Ban families likewise do so in respect of the Sean Graham Bookmakers massacre, which was a retaliatory, so-called retaliatory act to it. So the real courage exists actually within people. And I would say to you that it's important that that's also seen at the political level, that people remember accordingly in that way, rather than in the very choice ways in which it sometimes happens. So I think there's leadership needed top and down in our structure, within our victim survivor community, and within our politics. within our churches, within the academic sphere, right across the board. People have to understand that they have a stake and a responsibility to do better than what we have had before.
Okay, thank you. Claire, do you want to respond or?
It was just to say that I did look at potential legislation, and it was in and around screening, similarly to how we would do with the Section 75 of GFA. So it almost compels government departments to look at every piece of policy and everything that they take forward from a trauma-informed perspective to ensure that we're not re-traumatizing and that everything we do comes with a trauma-informed practice. And I think that's particularly pertinent in a post-conflict society. Not taking it forward this mandate, but who knows what might happen in the future. And I do appreciate that government departments are looking towards trauma-informed approaches, but I'm not entirely sure that they get it in terms of the discussion even that we're having. It has to be more than a tick box exercise. It has to recognise that, if anything, trauma is a sad fact of life for most people, but it's how we respond to it and how we respond to each other that I think is critical and important. And the worst thing for me is that government even re-traumatizes people. So just to give you an idea of where I was thinking in relation to that.
Okay, thank you. I'm going to move on. Harry, please.
Thank you very much, Chair. And Alan, you said you work across both communities, and that some would be surprised at this. I'm just wondering, how did that come about?
It's. I honestly don't know. We have what we would class as an open door policy. Whoever comes and knocks on the door, if there is something we can do to help them, we will do what we can. A number of years ago, we would have reached out to organisations within different communities and who may have had information, and tried to find out information on behalf of people. That closed down very, very quickly, to be perfectly honest with you. People got very suspicious of giving information in that way, and that's why I think it's important that within any legacy body there is an ICIRIR type process where people who have information can come forward and provide that information. At the end of the day, they are the people who own it, who have it, who can impart it. What we should be doing is trying to make that as easy as possible. Yes, there needs to be investigative bodies, but there needs to be ways of getting information to families that is verifiable, that is not about saying, well, I did this and this is why I did it. So that there needs to be a process there in place that allows that to happen. But again, coming back to your question, as I say, it doesn't matter who knocks on our door. I will go out and do the exact same job for anyone. Our process would start with whatever research is available. Most people who come to us at this stage are probably grandchildren, and someone has granny or granddad has died, and they go, I know nothing about what happened within my family, and I know nothing because it was too hard to talk about in front of my grandparents. But now I want to know what happened. So you're starting from a very low base of knowledge. So it's research from the very, very start. You're going to the newspapers, you're going to the Public Records Office, well, in the past we've engaged with the RUC, then the PSNI, the Serious Crime Review Team, the Historical Inquiries Team, the Coronial, whoever has that information, and try and find that and piece it together for a family. So the way I look at it is, I have got so much more knowledge of what happened in relation to my father's death through the work that the Pat Van Lincoln Centre helped me to do. Why would I not do that for someone else?
And would you say you've gained a confidence then across the divide? Have you been able to help and make a difference?
All I can say is, that the people that we have worked with have come back to us and thanked us for it, and have kept in contact with us over the years. To me, that's what's important. You've built a relationship, you've built a friendship, you've built a bond, you've built a degree of trust. And that's all I can say. If someone is still prepared to talk to me if we meet them in the street 20 years later after doing a piece of work for them, or 2 days later after doing a piece of work for them, I think that's what's important. And I suppose that's what being a bit more mature about how we deal with the legacy of the past is. It's not about compartmentalising what actually happened here.
Can I, to
Of course,
Can I know you work across both sides of the divide, if we would say that, and there's no religious or political differences, and I've recently seen your quilts and was very impressed with the work of those, but I was just thinking of the people, while they share their pain and that sort of relays to us how we can share in their pain, but would they generally share with each other or just with yourself, Kenny?
No, absolutely. They share very much together. And when you see two victims and survivors in the same space and they're listening to one another's experience, you can see their body language. It's etched within their eyes and across their face, in terms of the commonality of experience and some of the domino effects of that violence also, which aren't talked about enough. There's the murder, the death, but there's also what happens thereafter, the suicides, the broken hearts, the traumas, manifesting in cancers that are brought on as a consequence, stillborn births, miscarriages, right across the board. So there is a huge power in that. And I could quote as an example, the origins of our group should be well known to people in terms of where we were based, southeast Fermanagh. And any of you who know the narrative of that area will know that loyalist tourism had a very minimal presence within that context. So the predominance of users of our services in the early years were from a Protestant stroke unionist tradition. And those individuals could have taken the choice and tried to have remained in a moat syndrome mentality, that they were the most oppressed people ever. And that's what this society would have expected them to do. And they would have been resourced to do so. But they didn't. They have stepped out and they have said, we want to contribute to a wider peace. But they do so on the basis of a value system. So we don't accept that we divide on the basis of Protestant Unionist, Loyalist, Catholic, Nationalist, Republican. We divide on where we stand on the issue of violence. If you use violence, if you excuse it, or you explain it away, you're in one camp. And those of us who do not are in another camp. And we need to continually challenge people around that attitudinal situation, because guns and bombs going away doesn't resolve it. It's the mindset that is ever the appropriate way to deal with politics.
Thank you very much, Kenny. Thank you for what you do, and thank you. Sorry, I have no question for you.
You're okay. You're okay.
Timothy, please.
Thank you very much, Chair. I suppose, thank you very much, everybody that's came along today and contributed to the evidence session. I'll just pick up with yourself, a comment that you made that it was a dirty war. I certainly feel to a lot of people that would be offensive. It was a terrorist campaign with the sole aim of many to ethnically cleanse border areas, towns and villages and farmlands. And I don't believe them families would take on board your comments regarding it being a dirty war. Just moving on to the Pat Finucane Centre. I had a comment here today. An innocent victim's family was in touch with the office. An innocent victim's family who feels they can't come to the Pat Finucane Centre. They had sent me through the Irish Peace Process blog that focuses on Paul O'Connor. Does Paul O'Connor still work for the Pat Finucane Centre?
I'm sure you know the answer to that question before you even asked it.
Yeah. Well, you see why victims can see that as a stumbling block to coming to yourself based on that he was an active IRA terrorist from 1970 to 1972. And indeed on the blog it shows him standing with a gun at a checkpoint, an IRA checkpoint. Can you see why that would put people off coming to the Pat Finucane Centre?
All I can say is that lots of people in this society have pasts. And I think I've said on a number of occasions here today, we need to deal with that past. I hear what you're saying. The only thing that I would say in relation to that is that I've known Paul O'Connor for over 25 years. He has helped me, my family, and numerous other victims and survivors in this community. He currently is committed to non-violence and social change, and to help as many people in this society to become better people, to ensure that this society is a better place for people. And as I said, lots of people have histories here, but we need to get over those histories. We need to be able to move forward as a community. And I accept what you're saying. I accept that some people may see that as a hindrance, but there are other people who work within the Pat Finucane Centre as well, and anyone is welcome to come to our door.
Mr. O'Connor, in the past,
Timothy, please.
I think I've answered the question.
Timothy, please. The gentleman, I don't know him, don't know anything about him.
He's not
here to defend himself, Timothy. We need to be fair.
Yeah. Well, one comment that in the past, and it's available online, that he argued that somebody's military past disqualified them from being a judge. To many victims, being a member of the IRA surely should disqualify him from being part of a victims organisation. Moving on then to Kenny. Kenny, following on from the earlier evidence session, had picked up on the role of the Republic in the terrorism campaign, harbouring people. Can you outline what they have done in terms of legacy and your dealings with them in the past?
Yeah, a difficult question. I've been set for 16 years as its director since 2008. And I don't believe that the Republic of Ireland state has truly moved into a position of understanding that it was a contributor to our troubles. It still exists in a space that it had observer status. And the difficulty with all of that is that the UK government will bring forward what it brought forward, which was to none of our likings. And the Irish state was able to sit back and then almost quality proof what the Brits did. And the difficulty, I suppose, with that approach is you can never truly come to a fair outcome in all of this unless you have two states bound into the process. Omagh is an example in point. 70 to 75% of the Omagh atrocity relates to the southern side of the border. The team that were involved in that particular terror attack and the lead up, the other atrocities that were carried or bombings that were carried around that time, the movements on that day, how they were handled, how they weren't handled, etc., etc. So we look, I suppose, at the extradition record of the Republic in the earlier years of the Troubles, and again, it was very, very poor. The security policies that pervaded, the questions that still need to be answered around the formation of the provisionals initially, the training, the financing, all of that. But I do have to say as well, they're not on their own in that. The UK state absolutely has to answer these same issues. And there's no hiding place for them. Both of those states have got to come forward with a new level of maturity. And in my mind, they need to put the good, the bad, and the ugly on the table. Because actually, the rumour mill and the supposition which runs rife across our society is actually probably more damaging than what the actual truth is. Because with that truth, there could be context also provided in some circumstances as to how things unravelled as they did. But the failure to do so means that there is a void, a chasm, and then other things will fill that chasm and void, understandably. So the Irish state, we have not had a particularly positive experience, and that is inclusive of victims and survivors in our borderlands, but also those cases that we represent in the Republic of Ireland, in their own nation state. They have not delivered for Dublin Monaghan families. And I know Alan and his work Just for the Forgotten with Dublin Monaghan. The Belturbet case is another example. There are a raft of changes needs to happen in the approach of the Irish state if we're ever going to get any real movement there. And that needs to come as well from a more aggressive UK state, who, instead of merely taking the shots on the ropes, they need to also be prepared to ask the hard questions. I made a comment with the Taoiseach, the outgoing Taoiseach in the Southern government some time back, and I meant it like this, Timothy, that in the context of our experience on the border, we are stateless because we do not have the concern of the Irish state around delivering justice, truth and accountability for those we support here. And neither do we have the care or concern of a disinterested UK state who will not do anything to rock the boat in terms of those relationships. That's not a good place to be.
Ian, are representing a lot of families from a border county. Can you give some context, Kenny, into how many cases that you've dealt with where the perpetrators have came either across the border or have used land on the other side of the border to carry out their attack?
These figures are obviously challengeable, but we have looked in the rounds, and there are 550 to 570 murder-stroke killings which have a cross-border element to them. And while those attacks were planned from the southern side of the border, carried out, and people then returned, they're around that, and that's a very significant percentage, obviously, of our troubles-related deaths, so upwards on 20%. So that absolutely justifies the need for a structure to have been established in the Irish side of the border. You can't merely look at it in the context of the deaths that were caused in the Republic of Ireland. We have to look at it in the context of the murders committed in Northern Ireland, from which there was a southern dimension.
And finally, from your group, do you believe that Stormont is delivering for innocent victims?
I think in some ways, in some practical ways, there have been developments over the past number of years, but where there's a real challenge and difficulty is it's around the continued playing out of the troubles in a different way. And what I mean by that is the glorification of violence, which is absolutely systemic within this society. And it's not the preserve of one section of our community. It happens across the board. And it is deeply, deeply damaging to the quality of life of victims and survivors. They have to watch this, and it's like rubbing salt into, into an open, gaping wound. There's no abilities for them to actually get to a place to have a quality of life again, because this is being, mulled over so much. So there needs to be, finally, in our view, a recognition of the illegitimacy of violence across the board. There were always other options for people to take. There always were. We make good choices and we make bad choices in life, but we've got to stand by them and deal with them instead of trying to lie our way out of it.
Yep, no, thank you very much, Chair.
Emma, please. Sorry, this is going on, but there's got a lot of really good questions here. Emma, would you like to come in? Thank you.
Thanks very much, Chair, and thanks to you all for your presentations. I appreciate that you're all coming to us with your own lived experience, and I suppose at the outset would just like to disassociate myself with the remarks made by my predecessor there in challenging the views of somebody who's working with victims, and I don't feel that was appropriate. So I appreciate that you're all coming to us in good faith and talking about the work that you're involved in. I suppose I had some questions around the reconciliation piece and whether or not you feel that the strategy is aiding in that, or putting more barriers in place for victims and survivors. And particularly struck by the comments that you made, Sandra, around people suffering in peace, or dealing with all of these things silently, and the whole piece around intergenerational trauma and how that probably hasn't been explored. I know Claire made comments about that prior to my questions as well. Just whether or not you feel that it is aiding people now.
I think there is a fundamental need for service provision and accredited service provision, and the Victims and Survivors Service have done some very good work in relation to ensuring very comprehensive service provision. The Regional Trauma Network has now been created, and whilst there are issues in terms of the fact that some of the waiting lists are very high for it, it is still there as a process that has to be welcomed. So I think that fundamentally, Emma, we need to ensure that we can provide services to those in need when they are in need, that we're not putting them on a year's waiting list or 6 months waiting list. And that's a big problem for WAVE. I would think it's probably, and my other co-contributors can say if it's a problem for them too. But I can only assume that there are fundamental issues about long waiting lists and in relation to the struggles for people in terms of being seen. People talk about reconciliation nearly as if victims and survivors are not reconciled, and that imposition of reconciliation in the middle of the ICRIR was actually quite insulting, because, as Kenny said, victims and survivors are some of the most progressive people you will meet. They're not asking for anything that's not their right. The last government got precariously close to victim blaming. If only people could get on and be silent or get on and live, and we would be in a much better place. But we have a band of people who are contributing fully within our society and have taken the most risks for peace, but have actually got the least in peace in terms of what they've been delivered. So I think that the focus on reconciliation needs to be carefully considered in relation to what you're saying, because I know that people that we've dealt with rallied against that as some suggestion that they weren't reconciled with each other. There is hurt, there is pain, there is trauma, and I go back to the comments of that individual in relation to Canova. Canova gave her knowledge and power and control, and that's what we have to do through whatever process. So we need to ensure from the strategy perspective that services are available, and they're available when people need them, and they're there. The other thing that's disappointing has been the long delay in getting a victims commissioner. A veterans commissioner left in September. NIO moved within 6 weeks to recruit. Victims Commissioner gave notice last November. Some people will say, is the Victims Commissioner post needed? The sector is a very proactive sector, able to represent their own needs. But for individuals who don't come near groups, I think the Victims Commissioner has a very clear role working with the forum. And I think it's been regrettable that it's taken nearly a year for that post to be re-advertised. That's not serving victims and survivors well.
That's a good point. Emma, do you want to come back, or please?
No, well, not particularly. I appreciate that, and I think you've articulated that view around that imposition or burden on victims and survivors around the reconciliation part really well. And I suppose it's something that struck a chord with me. I know a few weeks ago when my party colleague Michelle O'Neill had stated that she was going to attend Remembrance Sunday, and obviously there were some people that had made a public objection to that. But in the most part, having engaged with people who were, victims of the conflict, they were quite relaxed about that. And, I suppose it's sort of ties into everything that a lot of you have already said around, people being far ahead of politicians or ourselves coming at this from different political perspectives, and that, victims very often really respect each other's right to remember their dead and to have that in whatever way is appropriate for them. So no, appreciate what you have said, and appreciate you coming to the committee today, and I think that's been really beneficial and helpful.
Well, thank you. I think we're just going to draw this session to an end. Really appreciate your time today, Kenny. I appreciate you're a very busy day and you made time for us. But
no, don't worry about it.
It was a really, really powerful contribution you all made. We have got the TU officials coming to us in early January to give us an update, their presentation in terms of victims and survivors strategy, so it was very useful today. Hopefully the clerk or the assistant clerk will let you know when that is, so if you want to watch in or if you want to engage with us before that, that would probably be very helpful as well. But thank you for now, and thank you for everything you do. Thank you. Okay.
Thank you.
Thank you. Okay, members, just moving on quickly then, oh, sorry. Are there any actions from that session that we want to take forward? Any suggestions? Go Go ahead. No, thought you were going to speak there. Do you know what strikes me in this? And I suppose we're in danger of straying too far. But you know, the Irish state was mentioned quite a bit today, in terms of what they said they were going to do, what they're doing, what they're not doing at present, and the role of the Department for Foreign Affairs. And I'm just wondering, is there something that we could do as a committee? I know that we've got no jurisdiction at all, but is there anything that we could do in terms of engaging?
After next, or is it this Friday? Is the election?
Yeah, oh yes, of course.
So
Maybe worth.
Are you thinking like an invite, Chair?
Well, no, well, I don't think that they're under any obligation to come, but I
No,
just
no,
think,
no, I
I just
know
think
that,
that,
but that
it was
doesn't
very
mean
clear
saying
today that they're a very significant part of the jigsaw in terms of our peace and reconciliation and the legacy piece. So maybe we should wait until we see the outcome of Friday.
That's a very fair point. We need to see who the new Taoiseach
Yes.
is. Yes.
So we could possibly put that as a potential then in the Legislation Forward work programme. And
Whether the committee would want to commission some research just to look at what has happened in the South until now, just to inform that process, or just so it shapes what the committee might want to ask.
that's a great
anyone that might-
suggestion.
Yeah.
Did you hear that? Okay.
No, I don't.
Go ahead, please.
It's whether the committee would be interested in commissioning some research just to look at what has been happening in the Republic, just to inform the kinds of questions the committee might want to
It
ask.
would be a handy paper to have sight of prior to a potential committee appearance.
Yeah. Is everybody in agreement with that? Did you hear that okay, Emma? And Claire? Yeah. Okay, it's just really to look at request to raise research paper into what has been happening in the South. So, and if it's of the quality of the one from last week, I think we'll be delighted to receive it. Okay, moving on then, the inquiry into gaps in equality legislation. So that's next week. There are some suggested questions in the committee pack at page 61, and the clerk has just indicated these are just suggested questions, and that those who will be at the roundtable event are at liberty to bring other ones in, other suggestions. So are people content with just those as suggested draft questions? Yep. Okay, and then there's the agenda there. So do you want to talk to the agenda?
So I'm very aware that members will have want to have a break between that and coming to the committee meeting. So the idea was to start relatively early. Guests arrive around 9 o'clock, are welcomed by the chair, and then have the round table discussions for around an hour. So we can arrange. So the idea would be that members themselves would be facilitators, and if we need any extra ones, we can find people to fill in, and then others will take notes at those tables. We'll collect that together as a final report from that, and include that in the papers for the inquiry, and then just some time after that for if you want to interact with the groups themselves. Yeah.
Okay, is everybody okay with that? Okay. So I know that a lot of you have indicated whether or not you can come next week, but just if your circumstances change during the week, if you can just keep the team here updated, then that'll allow for organisation. Okay, members, draft forward work programme, you'll find it on page 64 of your meeting pack. Just to advise, we have been able to reschedule the session with Forest na Gaeilge and the Ulster Scots Agency. So they are coming next week. We are going to be in room 29 because we need the simultaneous interpretation. Only those people appearing in person, attending in person, will be able to avail of that interpretation because they haven't got the technology. But the recording that will be going out on YouTube on the Assembly website will have the subtitling on it. So, but I think Stuart, you won't be able to be here in person, so we're going to try and see if there's a workaround.
Definitely online.
Okay. Okay, are members content with the remaining briefings for this year and the forward work programme suggestions for next year? Great. Okay, correspondence then, members, page 69, you'll find the summary of committee correspondence, and there's one I want to pick up on, and that was the request from Advice NI regarding the IMA's evidence session to committee recently there, and they would like to come themselves just to respond to it in terms of some of the issues that they've experienced with supporting people. Everybody in agreement with that? Yeah, Okay. Okay, anybody else want to raise anything under correspondence?
Page 100, on the back of the evidence session we had where a lived experience alleged that the housing executive was institutionally racist. I just thought it was worth highlighting the response from Minister Lyons, who obviously would be the Minister with oversight of the housing executive. Have we a date for them to come back to committee yet?
Not yet. It'll be in the new year. So we're putting those dates together and agreeing with the department when they can give briefings as well. So we'll arrange that hopefully for January.
It's at the top of the list for prioritisation in the new year.
If there is evidence of such, and I said this in committee, if there's evidence to support such a claim, that has to come to the fore and it has to stop, and it has to stop immediately. But if there is no evidence that comes to support that claim, has the committee a duty essentially to recognise that that was made public and it went unchallenged on the day? Or is it a case of it's something that's happened in open session and they have the chance to refute it?
Yeah, well, we're inviting them back to give them that opportunity, but I suppose we could go back to the gentleman who made the assertion and see if he has any specific examples. I have a few, but they're not necessarily in terms of institutional racism, but of just some issues around the rehoming of people who are from ethnic minority backgrounds who maybe didn't feel that they got the service, but that's different from the people who've a direct lived experience. So,
because I think it's important on the day that we could bring that to an end, to a close.
Yeah, and that's why we've invited them back.
Executive.
And that's why we've invited them back. But thank you for sharing that response from the Minister. Okay, any other business, members?
Chair, just quickly.
Yeah, go ahead, please, Claire. Yes.
Chair, we had a presentation in relation to the mother and baby homes. Maybe prior to the summer, maybe even early September. At that meeting, they had talked about £250,000 being available to them in relation to public awareness raising. I understand that that's now been reduced to £80,000, and there seems to be an issue with them actually being allowed to spend that until after March. I suppose there would be concerns there just in relation to timelines, that if they were to do such a campaign at that point, it could give rise to a lot of interest that, would they have capacity and resource to deal with that? Is there any way we could follow up just to understand that? Because I think even it was when we did meet with them, we felt that the £250,000 in itself was quite minimal. So now to be reduced to less than half, I think that's a concern.
Okay, no problem. So is your proposal to write to the department then for an explanation?
Yeah, please.
Okay, is everyone in agreement? Okay, thank you. Any other business?
Thank you.
No. Okay, so we'll just close the meeting there and just remind you that same time next week, but in room 29. Okay, thank you. Thank you.
Committee room 30, sound.